Okay, we're going to bring the meeting back to order, and we are going to start out with item number 8 on the agenda, appeal number 2016-789. Ben?
Yes, this is appeal 2016-789 by Leah Lurtrell. Pursuant to Calaveras County Code section 3.56040, all individuals engaged in commercial cannabis activity are required to pay the cannabis activity tax. And as of March 12th, the appellant had not paid the outstanding balance in full, and subsequent to that, she was denied.
Okay. Is the appellant here? Okay. So, do you guys have any questions?
No.
Okay, well then I will go to public comment. Does anybody have any public comment on this case? Okay, I'm going to close public comment, and I'm sure you have no rebuttal today, right?
Nope.
Okay.
Do you have any indication from the person that they're going to be late, or?
I have received no contact from the appellant.
None whatsoever.
None whatsoever.
Okay.
Might answer this.
Yeah. Are you Mrs. Luttrell? No. Okay, thank you. Okay, so can you read the recommendation if nobody has anything further?
Are there similar amendments as with the other tax base?
I would suggest exactly the same amendments.
All right.
As the amendments were amended by county government.
Got it.
Well, I was waiting for Mr. Laddish to catch this, but he didn't.
Oh. You're falling on the job.
Yes, sir.
We're ready.
Page 1 of the resolution, paragraph 1, numbered 1, Calaveras County. It's still a capital C for county.
I can't believe you missed that.
Shocking. I resign.
No, you don't. It's not that easy. Okay, now we would like a recommendation, please.
Staff recommends that the Planning Commission adopt Resolution 2018-031 as amended, thus denying Appeal 2016-789, thereby upholding the Planning Director's denial of Application 2016-789.
As amended.
As amended.
Okay, can I get a motion, please?
I so move as amended as amended.
Thank you. Second? Thank you. Okay, all in favor say aye.
Aye.
Opposed, say no. The motion carries 5-0. They have 15 days to appeal this to the Board of Supervisors. You want?
Yes, they do.
Thank you very much. Okay, so Ethan's going to win a bet today. Number 9, appeal by the number 2016-803.
Before we begin, I just noticed there is a very large typo on the front page of the staff report that it is a appeal by Ortal Gave on behalf of mainly Concepts of Calaveras, and it is not. He is appealing on behalf of OG, his corporation, not the corporation from the previous items.
Okay.
With that, this is appeal 20. Oh, sorry.
It's okay. He's going to do his presentation, and then we're going to have you come up. Okay.
This is Appeal 2016-803 by Ortal Gave on behalf of OG, and this is once again a failure to pay the Measure C tax after demand for payment in full was made, and subsequent to that, he was denied.
Okay. I think he's done. You can come on up.
Good afternoon, everyone.
Good afternoon. So we give you 15 minutes for your presentation to explain to us why the county's wrong.
Okay. Simply put, I paid a tax for another parcel, another cannabis tax in the past that I shouldn't have paid, and instead of getting the refund for it, it took about 4 to 5 months to get that refund back. In the meantime, that was That's when I was supposed to pay back, I was supposed to pay the next tax, and until I could have done that, the county had, the tax collector had my money to pay that tax.
Did you appeal to the tax collector on that issue?
I did.
Do you have proof?
I have emails, and the planning director as well, Peter Maurer, was involved in it, in the negotiations of back and forth with her, as well as Brian Moss and Jack Garamendi.
Okay, so you got your taxes back after about 4 or 5 months.
I got my taxes back. That was already the end of December. The money the reason I needed it back so far is I was paying interest on that. It was a loan from a lender, and that about $10,000 of interest and late fees, because it was after when I was supposed to pay it back. And I had told Barbara Sullivan that I'm going to be late on paying my next tax, the upcoming tax, because of this situation. She acknowledged it, and she said, I understand, but I can't do anything about the late fees. And that was about it. And then I got a letter of denial in March.
Have you currently paid the taxes now?
I have not. I have not paid the tax. I have spoken with Peter Maurer over the phone, and he had told me that he will speak to, because I wanted to fix it before it came here. And he had said that he had spoken with Barbara Sullivan, and she said at the moment I would have to bring it to you guys.
So, question for
Can
you.
I interrupt
Yeah.
for 1 second? I would like Peter to make a statement over here.
Well, that's not quite my recollection of the conversation that we had. You had asked if I could overturn the denial because you had been waiting on the money, and I said, no, at this point I can't. Whatever arrangement that you had, at this point, the only entity that could overturn the denial is the Planning Commission. It really had nothing to do with the actual payment of the tax. It had to do with the denial of the registration. So any issue dealing with payment of tax is between the grower and the Treasurer Tax Collector's office. So we don't get involved in who pays and how much. It's based on the registration and the tax demand by the Treasurer Tax Collector. And any appeal of that is handled through the Tax Collector's office, not our office. The only action that I was involved in was, the appeal of the denial of the registration itself.
That was a misunderstanding then, but that's basically how it unfolded and how I got to this situation.
Okay.
So on the other property that you paid taxes on, that's a whole nother,
Turn your mic on, please.
we're talking about a whole nother application, a whole nother,
So just to give you a quick background, I had got denied on that application in December of 2016. January of 2017, on that other property, I was told that I needed a grading permit to submit it. And then in May of that same year, I was sent a tax bill. And I have complied with everything up to there. And not only did I pay the tax on a property that I was not growing at all because of the denial, I paid the taxes with interest, $26,620. And then once I found out that I wasn't even supposed to pay it, I spoke with Barbara, and she had instructed me it's not up to her, that I should speak with Peter Maurer. I went to Peter Maurer and I explained to him the situation, and he rightfully so said, it's not up to me, it's up to the tax collector.
so originally you had 2 grows and you were supposed to pay taxes on both.
On both. I had paid my taxes on both of them. I wasn't supposed to pay my tax on the other property because it was denied, but I did because I had instructions I got a letter in the mail. I didn't want to cause any more issues, and I did everything I needed to do, and then figured out if I was wrong, then I would get my money back.
Okay.
From that date, I never grew. I never grew on that property at all in 2017. There was not one single plant there. It was,
I was just confused. I wanted to make sure that you didn't pay taxes on a property that weren't yours, but.
No,
that's not
they were
what-
both. They were both under my name, the same application, the same everything. They were adjacent to each other as well. But I just did, like I said, what I was told to do, and I would have done the same thing in this situation, because even if I don't pay my taxes for whatever reason, like someone I heard there was a ban, I'm still liable for those taxes, regardless of if there's a ban or not. So why not pay it beforehand so you don't have trouble in the future? I couldn't do it because my money was tied up wrongfully in the hands of the tax collector. And instead of refunding me the money right away, it was kind of like a cat and mouse for a little bit. I understand paperwork and stuff, and until I got Jack Garamendi involved, I did not get that money back. And then I finally did forcefully, and then by the time I did, I already accumulated about $10,000 in interest and late fees that I didn't even ask the county to pay me refund me back because of the situation. I took it upon myself, but I don't make that much money, so to pay it over right away is very hard to come out of pocket $10,000 on top of my bills. So it took me a few months, and I had explained that to Barbara. It wasn't in writing, this was in her office, and she understood the situation. I mean, common sense, I accumulated debt, I want to pay it off, and then I'll pay my taxes, no, not a big deal. I didn't think there was an issue, and then I got the denial.
It's not in our job duties, in our jurisdiction, to determine whether the tax was validly assessed, et cetera. It's if the tax has become finally due and payable, we have nothing to do with your dealings with the tax collector's office. So, did you file an application for redetermination from the tax bill that you have not paid?
I don't understand.
Well, there's an administrative procedure that people have to go through to keep their tax liability still in question. And one of the things that needs to be done is a filing of a petition for redetermination within a certain period of time of getting the tax bill. Do you have any sort of administrative procedures pending with the tax collector?
I acknowledge the tax, and I'm taking. I had to pay that tax. It's not. I wasn't trying to dispute that at all. I wanted to pay it, but my money was tied with the county wrongfully, and they were supposed to refund it in a certain amount of time, and I was told I would have had that money.
What is your understanding of the current position of the tax collector with regard to these taxes?
So the tax collector just collects the taxes. I mean, she has nothing to do with the.
No, as far as late payment and et cetera. I mean, you say you've talked with her.
Yes.
I'm trying to get just what your current understanding of the tax collector's position with regard to the taxes you have not paid.
Her job is just to collect the taxes.
Okay.
From what I understand, I mean, I don't think she has another position in this scenario.
You know, we're stuck under the laws. If they're due and payable, we can't do anything about that. And as you say, you understand they're due and payable. You want to pay them.
But I can't because the tax collector collected the money, and I had informed them before I paid them that this property is denied. Do I still pay it? And their only answer is, you have the bill. It was sent out to you. This is at the. So I said, okay, I understand. That makes sense. So I'll pay it, and then we'll take it from there. And then that's exactly what I did. And instead of taking a week to 2 weeks like it was supposed to, it got dragged on for months, and not 1 or 2 months. And every month I'm paying interest on it. And then when it was finally due in the lump sum, I accumulated legal fees on the other party that I had to pay for. Otherwise, my property would get foreclosed on. So I paid everything I had to pay, and then now they're saying, well, not only do you have to pay taxes, but just pay another $22,000 on top of the money that you wrongfully paid. I'd have to come out of pocket almost $50,000 just to pay a $22,000 debt. And it wasn't that someone else had the money. It was it was the tax collector. It was in her hands. I mean, it would have been simple to either ask me to transfer it or something like that. Her answer was, we can't commingle funds. I even tried doing that with the property taxes that I needed to pay. And then it got to a situation where I was going to Peter Maurer, and then that took a few days to go back to Barbara, and then back and forth. And then finally, she said, it's not in my hands. It was, all right, sorry, let me go back. First conversation, it's not in my hands. Go to Peter Maurer, which is weird because he's a planning director. I went to him. He found it he communicated with her. He said that it's in her hands. I went back to her. She said, once again, it's not in my hands. You have to speak with them. And if they can't do anything, then there's nothing I could do about it. And that went back and forth. Instead of over a few days, it took 3-4 months. Finally, the last thing I got out of her after Peter Maurer confirmed that it is in fact hers and she has no one else to send me to, she told me to go to the administration's office. And she said that they would be able to help you. And then I went to Brian Moss, and I told him the exact situation. And he looked at me like I had 4 heads. Why are you coming here? It's not up to me. You paid her the taxes. So I went back to her again. And then it was a back and forth again. And then finally, Brian said, more than likely, this is not going to get situated. Why don't you speak to your to your supervisor, which is Jack Aramendi? And I did. I caught him in a meeting, and as I'm walking with him back to the planning department, he said verbatim, "We don't want your money. You should have been refunded this money a long time ago." And then that's when Barbara finally took me serious and called me into the office and said, "Well, I spoke with Jack, and it looks like you are." She actually put it in an email that I have that I should be refunded back my money. But she said that it's her first response prior to it was, "We can't commingle funds." Then she said, "Well, can we take some of this money to pay other?" I said, "I can't, because if I do, then I owe more money out of pocket to these people, to this lender. It's not a personal loan." And so she said, "Understandable." And then she tried to take off money for the property tax, and I agreed to that. It was a few $1,000s. I said, "You know what? Let me get that out of the way." And then when she was looking at it, her response verbatim was, "It's just not going to look good if I refund this money at this time." And I didn't understand what that meant. And then instead of refunding the check when it was supposed to be December 6th, I went actually to go collect it, and I was very emotional. Ethan was there, and I was supposed to pick up a check that day, and it wasn't there. And then Ethan helped me out, and it took a few more days, but I got it before the end of the month. Still not before the January 1st deadline, because I got it on the 28th, I believe, or the 29th of December. By the time I deposited, I accumulated more interest and more fees because it wasn't by the January 1st deadline, and that's the situation I got into now. And I'm not asking for money, I'm not asking for a refund. I just needed a little bit more time to pay back. The issue that I didn't cause for myself. I did exactly what I was told, and I put myself in a bad situation that accumulated a lot of debt. And I just needed just a little bit more time to pay back that debt that I shouldn't have paid back in the first place and make right with my taxes. I've done that in the past. I've paid my taxes on a property that I didn't even grow on. I had no intentions of growing because it was denied. So why would I not do the same thing in this instance when I already went through the entire application? I went through everything checked out. I've done everything. The only issue was the taxes. My property was inspected. Everything was in compliance. I was even actually sent a denial letter prior to this tax for issues that weren't even an issue. And I went back and forth with Thomas Watts at the planning department. They clarified that. Peter Maurer rescinded that denial, and I got a refund for the $500. And then a few months later, I got this letter.
I've got some questions.
Sure.
On the parcel we're concerned with now, did you pay the first installment?
Yes, sir.
Okay. And at what point on the other parcel that you got the refund, was it acknowledged to you that you were due a refund?
When I had paid the tax, and then through the denial process, I was told that I wasn't supposed to pay the tax. I was denied. I didn't grow on it. Why did you pay the tax? My answer was, I got a bill in the mail. I didn't want to have more issues, understandably so I did what I was told. I paid it, no questions, and then we got to this problem.
Okay. And how much was that payment that you made?
That was for $26,620. I was late by a day, so they charged me $4,620.
So it was $26,000 that you had coming to you as a refund?
As a refund, which would have been more than enough to cover the $22,000 tax bill that I had to pay for May to December.
So you had a refund due to you at the time that the second installment of $22,000, the bill for that was sent to you?
It was after the installment was due. I had received that money. It wasn't before that it was due. I got the money after
I understand you got the money later, but you were owed the money.
Yes.
As of November 15th of last year?
I was owed that money about 3 months before November. It just took that long for me to get the money.
So the tax collector has money that's owed to you
Prior to the bill.
at the same time that the tax collector sends a bill out to you.
Correct.
All right. And the tax collector owed you more money
More money, yes.
than what you owed the tax collector.
Right.
All right.
She did not want to
I
commingle
understand
funds.
it. I understand it. All right, now I have a question for the other side. isn't there a principle of law generally that if there are two competing demands between the same parties, that they cancel each other automatically under the Code of Civil Procedure?
You know, I actually don't know the answer to that, but what Barbara wanted to do with this particular situation, I represent her with regard to these matters, and I dealt with her throughout the resolution of this process, was to credit the money that was owed back to him to the second installment, which is the installment that we're talking about here today. Her general policy is not to give people money when they owe her money. And she, under the Chapter 3.56, there's a provision dealing with refunds where an assessment is erroneously made, and the person can claim a refund, or it can be credited against future installments that are due. And at the time that we discovered the error, the planning department has a list when that they give to Barbara. Barbara looks at the list and makes a determination based on the square footage on the list of who owes what. And the denied site that Mr. Gabby had already been denied on was mistakenly on that list. So he got a bill that he should not have gotten. He paid that bill. And then Barbara wanted to credit that payment to the second installment on the site that continued to be in the system. And rather than doing it that way, Mr. Gabby, for reasons he explained, would have rather just have the money. And I have no idea why it took so long for him to get the money back. Exactly, it did take quite a while, but he eventually got it back. But he could have just left it in there, and it would have covered a second installment on this other parcel.
Well, Mr. Goodbye, after you got the money that you were owed, why didn't you write a check to him for the $22,000?
As soon as I got the money, I was already in negative about $10,000 after I had paid back what I needed to pay back. So now it took me a few months to make that difference in money that I accumulated because it took so long. And the reason she told me why it took so long is because she doesn't want to give any money back. It wouldn't look good on the books. Or she didn't say it in that terms, but she said it wouldn't look good is the term that she used, which I understand. Maybe it didn't look good that she's refunding so much money. And it took months of begging and pleading and going to Peter Maurer and Brian Moss and finally Jack Garamendi before she even acknowledged what I was asking for and allowed me in her office to explain to her the situation. And only at that point did she ever say, because I tried to pay other debts beforehand, and she said, you can't commingle funds. It was only after Jack Garamendi got involved did she say, okay, well, why don't you sit in my office and let's figure this out. And then we finally came to the conclusion that I can't afford to pay the $22,000 right now. The deadline is not, the due date is not present yet for the taxes. And I told her, and then she went ahead and said, well, she went back on her word when she couldn't commingle funds. She said, well, couldn't you pay your property taxes? And she didn't say that. She said, well, I'll have to deduct your property taxes. And I said, fine, it's a few $1,000s. It's not what I want to do, but if that's the only way I could get my money back, fine. And at the end of and that's the process that we went through, and that's also an email as well. From her, Brian Moss, and I think Jack Garamendi is CC'd on there as well.
So your refund that you were due was a little over $26,000,
Yes.
and she deducted roughly $2,000 for the property
So
taxes?
she was supposed to, and then when I got the check, it wasn't deducted at all.
So you got a check for how much?
$26,620.
Okay, now tell me again why you didn't turn around and write a check to the tax collector for the $22,000 that you owed on the second
I
installment.
could have done that, but the lender would have went through a foreclosure proceeding on the property because I had a lien against the property for that money that I was owed at that time. And that's why they were nice enough to say, well, we won't foreclose on you and go through that proceedings if you pay the legal fees that we came out of pocket for. So the interest plus the legal fees put me behind before I even got the check in my hand. So even if I had wanted to, I had an obligation to not lose my property and pay them, and then I had $10,000 to come up with to pay the county. And I had explained to her it's going to take me some time, and maybe I should have had it in writing, but she just said, that's understandable. I just can't do anything about the late fees. And I was willing to pay the late fees, even though I should have never paid any late fees. I shouldn't have paid the $26,000. I shouldn't have paid to borrow the money from a lender. I shouldn't have paid all those fees. I have not once asked the county for a refund for their error, their acknowledged error. And instead of saying we understand it, they also denied me on another property because how can I pay when you're holding my wallet? I can't pay. I would have to come out of pocket almost $50,000 just to make this whole, and that's not fair. It doesn't.
So just to put things in just for me for a little bit here. When the county was holding your money,
Yes.
had they refunded it right away, you still wouldn't have paid your taxes, correct?
If they refunded it right away, I would have given it back to the lender and then started a new loan with them, which is what I was planning on doing. So now they're made whole. This is finished with. Now I take a new loan for a less amount and then pay the taxes, which is what I was planning on doing from the beginning. But because it took so many months, I didn't have enough time to even negotiate. I just had to pay them, and I was out already $10,000. And then if I had some more time to pay it or figure something out, I would have been able to pay it easily. And then that's what I would like to do and still like to do. I mean, I've done it in the past. I paid for a property, my taxes for a property that I didn't even grow on just because I got an error in the mail. I went out and paid it without question and then took care of it. I did everything I was supposed to do by the book. So why would I would have liked to do it in this situation. I just wasn't given the opportunity.
Why would you pay a $22,000 tax that you didn't owe?
Because at the time I didn't know I wasn't supposed to pay it. I thought it would jeopardize whatever I had over here. And when I went to the tax collector and I explained to them I'm not sure what's going on, they say we can only accept payments. You're on the list. You're supposed to pay this tax. So I can't imagine the county would mislead me or something. So I paid what I was told to do.
I have a problem with the math. You said you got a check for $26,400.
620.
620.
Yes.
And you got that in the latter part of December, correct?
Yeah, December 28th.
And yet that you had accrued something like $10,000 in debt that you had to pay back?
In interest and late fees, yes.
So
So you're talking
somebody
about?
else, right? It was a lender.
I was a lender. It was a private lender.
trust
Hard money.
in it.
Yeah.
So that gives you 16 grand available.
Right.
Why didn't you pay that to the county?
It's not my money. As soon as I had received that money, I had to give them that money, and I'd still have to come out of pocket on top of that. So it wasn't. I had to do that to save the property. Otherwise, it goes into foreclosure.
What was the 10,000 that you were talking about?
The months that the county held my money, I had to pay interest every single month. And towards the end, I had to pay legal fees so I don't get foreclosed on because the money wasn't in time. I was supposed to receive the money beginning of December when the email was sent out.
So what was the total amount you owed the lender?
The total would have been
December?
It would have been 36, a little bit less. It's not exactly 10,000. I don't have the exact number, but it's a 26,620 plus the remainder. I had borrowed more money that was already paid for, and that was the remaining balance. Because I was supposed to, the email was sent December 6th from Barbara Sullivan, and they didn't want to refund the check because they weren't sure how to refund it, so they didn't want to give it to me until February.
Did they offer or did anyone discuss with you 3 or 4 months earlier this option of simply applying the 26,000?
The answer was no, you can't. You cannot commingle funds. That was Barbara Sullivan's.
So I heard testimony a little while ago, was it Peter or Ethan, somebody said that you didn't want to get that.
That was after, that was in December already. If this was prior, when I could figure something out with the lender and speak to them and renegotiate with them, fine. But the end of December, the money is due within a day or two, and the check still hasn't cleared. I'm not in a position to say, go ahead.
All right. Let's go back to August or September, that time before, when you actually paid the money.
Yes.
Do you know that date, approximately what date that was?
It was before that. It was August would be the latest. I'm pretty sure it was before August.
Okay,
but if not, it
you
would.
wrote that check and you just kind of blindly doing what they told you to do. At some
No, not blindly. I
well,
know.
at some point after that, you found out that you really didn't owe the check.
Right.
The money, right?
Right.
How much longer? Was it a week, a day, a month?
Something like that. I don't know the exact date, but something like that. I had.
Pretty soon.
It was pretty soon because I had gotten another denial letter. I think right around that time on the property that I paid the tax that the property's that I lost. It's denied. And then when I went to ask them why is it denied when I paid my taxes, they said you should have never paid your taxes. And that's when I acknowledged that I should have never paid it.
And that was approximately when?
I want to say August, maybe. No, it had to be before then.
And you asked for a refund at that point?
Right away, yes. And then I went to the office, and then that's when she said right away, it's not in my department, speak with Peter Maurer, And then that's when the cat and mouse, like back and forth.
Nobody in this chain, neither Barbara nor Peter or anybody else at that point offered to apply that overpayment to this tax bill.
At that time, no, it was 6 months before it was 5 months before the other payment was due.
That is, why would he not owe taxes on a denied registration?
It was denied
Well,
before
if the
Measure C.
denial occurred prior to the tax bill going out, then they did not receive a tax bill. As I recall, this one was somewhat confusing. It was denied, it was rescinded, and it was denied again. And I don't recall all the details. So there was just some confusion surrounding it. We ultimately determined that, it had been denied and, hadn't been growing on it, and the
Okay.
tax bill shouldn't have been applied
Okay.
to the other side.
Okay, so here's the issue that I'm having with this. You paid the taxes on the wrong lot, but you still owed them on the right lot.
At that time, I didn't.
At that time, you didn't.
I didn't get a bill for another 4 months, 5 months after that. The bill wasn't sent out until, I think, November or December of last year. And I paid the tax months before that, so I didn't have to pay anything at the time. There was
paid
no
the
debt
first
owed to the county.
So the first installment was paid on both parcels.
Yes.
Okay,
The second installment didn't come out till after.
okay. So I understand you have a hard money loan. I get that. I understand the late penalties and the fees racking up on you. But I also understand you have an obligation to the county as well, and by not paying this, it cost you the registration. By not paying the loan, you faced foreclosure. You were kind of in a pretty tight spot, but that doesn't change things up here with the fact that it was due. You had to pick and choose who you had to pay first and who you couldn't pay. We can't change the tax code.
You held the money. If someone else held it outside of this place, I can understand that. That's
Okay.
up to me. But the county who's denying me is holding my money, not hostage, but for whatever reason, for months. If you just said, we made a mistake, we are so sorry about that, let me give you back your money. I didn't even get that. You're going to have to wait. And you're going to have to wait longer, and you're going to have to play games and go back to Peter Maurer and Brian Moss and Barbara Sullivan and Jack Garamendi and go in circles when it could have been resolved within a day.
And if it was resolved in a day, you would have gone and redone your loan, your hard money loan. You would have turned it over.
Absolutely. I pay taxes on a property I didn't even grow on just to do the right thing. Why would I not do it on something that my life depends on? Mm-hmm. Simply put, I have done everything. If there was other issues, I could understand, but I have done everything by the book. I have passed inspection and all the other issues. Everything was taken care of. It's just this tax issue.
If at the time the second payment was due, that you couldn't afford to pay, if at that time they'd applied money from the other, from the payment that eventually was decided you didn't need to pay, if they'd made that switch, what would have been your situation with the loan? At that point, could you have gotten another
In the beginning,
loan?
once I satisfy that loan, I could, without...
No, I'm not talking about once you satisfy the loan. If the county had done,
what they said they would do.
applied the money that you shouldn't have had to pay to the second payment that was due on the property we're dealing with here, if they'd done that, I don't know whether the loan company had already taken action against your property. What would have been your situation then?
At what time, at what month?
I think at the moment that you said to Barbara, can you apply that to the right property? And she said, no, because it's commingling.
Yes.
What if she had done that? Then you still wouldn't have the money.
If she had done that prior to all these problems, and I could have fixed the situation with the lender before it got into...
Okay, so you're saying pre.
All these, if I had gotten the money when they told me that they would refund it, I refund it back, I am now back at zero.
Okay.
Now a bill comes in November or December, and they say, Ortal, you owe us $22,000. I go back to that lender, who I have a good history with because I paid him back with the interest. Hey, I have another bill, I need some help. No problem. Here are your new terms. You have X amount of days to pay it, and so on. But not only did I miss my deadline, I also had to pay for their legal fees to take action against me because the county was holding my check for no other reason other than confusion.
Okay.
And I would still pay it, just like I did. I paid my a bill that I wasn't supposed to pay.
Had the lender taken legal action at the time the second payment became due?
Would they take, no, it wasn't, no legal action should have been taken.
No, but had they taken their foreclosure steps and this sort of thing,
Okay.
incurred the legal fees and stuff, at the time
Which
the
month?
second payment became due for the property that we're dealing with here?
So, is this, when I gave the check for the taxes, is it, at what month are we talking about?
No, I'm just focus on the bill goes out for the second payment.
Okay.
$22,000 for the property that we're dealing with right here.
Okay.
Okay. At that point, what was your status with the lender?
I would have been paid whole. I would have had no status with the lender. I would have finished my deal with them because I had gotten my refund back. I would have gotten.
No, I'm not saying because you've gotten your refund back.
No, I understand the question. What would I have
Well, the
done?
question is what, well, it led to my earlier question.
Okay.
If a second question can lead to a first question. If the county had credited your account when the second payment became due, if they credited your account with the $22,000 so that the second payment was paid,
Mm-hmm.
would you still have been in the soup with your lender?
No, because if.
They had not yet taken foreclosure steps? And
Correct.
encouraged
So
it? Okay.
if we go back to when I paid it, right? So I paid it in August. Now, if they said, or around that time, if they said, all right, Ortal, you paid it wrong, you shouldn't have paid this, that would have been, let's just say, September. So in September, I would have gotten the refund. I would have made the lender whole. So now I don't owe him money, and there's no more interest accruing. Now I get a bill in November. Do I have the money? Do I not have the money? If I don't have the money, I go back to that same lender, and I say to him, I need to borrow money. He's going to say, you're in good standings.
But I'm not talking about August or September. I'm talking about.
I wouldn't have had an issue back then if this was settled in August. What I'm
No,
saying,
I understand. I understand that completely.
Okay.
I'm just trying to figure out, come the second payment's due date.
Right.
Okay, you get the bill for this.
I go get the money and I pay it right away.
But, no, you don't have the money.
You don't have to.
I would
I mean,
go to the same
okay,
lender.
Yeah, that would be if you were already paid up with them. But I'm not saying, in my hypothetical, you haven't been paid yet back
Okay.
by the county.
Oh, okay, so I haven't been paid back
You
yet.
haven't paid.
Okay.
No, they're still holding your money.
Okay.
But you get the bill and you simultaneously get a statement saying, and since we are holding $26,000, we're crediting your account. You're paid up for the second payment.
Okay.
Okay? What I'm trying to get at that point, on that date, what was your status with your lender? Could you have renegotiated with, or would you have been foreclosed again?
I mean, this is hypothetical,
Well, I
but
know.
if I went to the lender and I had told him I have about a month to pay off this debt, I want to continue this debt and extend it, possibly, but I had a deadline to meet, and because of the situation, because it took so long, I had less room to pay him. So had I paid him back in when I got the refund, or when I wasn't supposed to pay it, come August, September, I don't know him anything, I could have new terms. But the terms I had on that loan was ending in December. So that's the reason why I couldn't go back to the lender and say, hey, I have a check coming. They're not going to want to hear it. They're going to want their money.
Okay,
if
so,
I-
I was going to say,
One
go
more.
ahead.
As I understand it, at one point you were told, when you asked about the erroneous payment that was made, you were told, no, you need to make it because that property's on the list.
Yes.
Is your understanding it was on the list erroneously?
No, because I got denied in December, and then I got in December 2016. January 2000, I was denied for grading, for whatever, grading and some other things. Come January, I was told, I got another letter in the mail saying, you're not denied for grading, we need a permit. In that process, I started getting a permit, a retrograde permit to submit to the county. Then I got another denial letter in, I think it was May or something of 2017. Meanwhile, I have not grown at all this entire time. And then because of that, I got this letter in the mail. So everything leading up to this point made me believe from the county, from the mail that I've been receiving, you have to pay your taxes and you have to get a grading permit. So there is no issue or question into why I shouldn't pay it. You know, it wasn't like you shouldn't pay this, you're denied, but here's a tax bill. you're still in compliant, get us a grading permit, and also pay your taxes.
Okay.
So I paid my taxes.
So we're kind of asking and going over the
same,
same
yeah.
thing over and over again. So what I'm going to do is have you sit down. Barbara Sullivan's in the room. I'd like to
Okay.
have her come up and
Perfect.
talk to us if possible. Thank you.
Thank you.
Good afternoon.
Good afternoon, Barbara Sullivan. I was overhearing, and it seems like there's some issues that were a little vague there, so I wanted to clarify. When I get the list from planning for the installments to be billed out, whoever's on there gets a bill. So that's what happened with Ortel. So we gave him a bill, he paid on it, then he realized that he needed to pay apparently somebody else back from that money and that we should return it to him. That's when we found out he was denied and we should possibly give it to him. Well, that's not my decision. I'm the tax collector, not the giver out or refunder, I should say. So I said, it has to go through Peter, has to go through admin. We went that route. Well, the funny part was we've never had this happen with the cannabis so far. It was a new procedure on if we were going to do refunds, how were they supposed to be handled? So that took time. So I think that was from November, December, we started working on it. By the time he got the refund, I'm not sure because I wasn't a part of actually doing the refund. I heard something about commingling. I would definitely accepted that payment on his second installment. But he told me he needed the reimbursement and he would definitely make the second installment. That did not happen. So I just want to, there's no word about commingling. No commingling.
When was that statement made?
Oh, it had to be December because it was around tax time. That's why I was mentioning the property taxes to him because that was due too. So
I believe I've heard him saying that this goes all the way back to 2 or 3 months before that, when he found out that the payment he had made, the $26,000,
correct. And like he said,
was not necessarily due,
or he paid it and he shouldn't have paid it that
Shouldn't have
time.
gotten
You're
the money back.
He had an appeal pending, I think, too, on the denial part of that. I wasn't sure about that. I'm not involved. But the thing, like I said, I collect the taxes. So if I sent out a bill because I was instructed to do so, I did. Then when it's an error, we go back to Peter. Then that was like, okay, maybe we should give him his money back. Okay, well, I still don't have the authorization to do that. So, but he did have a second installment coming up that he could apply it to. And he told me he would pay that separately.
We've heard about the property, the other property, I'm going to say. This property is the property we're dealing with right now where the taxes are due. The other property was on a list and therefore he had to pay the taxes on it initially when he
so,
made
correct.
that payment. Can you describe what the list is?
Oh, that I get to be billed on?
Yeah,
Okay. Yeah, basically, it's a planning list of those permitted or have permit to do so with the cannabis. And they're either verified, validated, or approved at that point. So then I get that list by, the first one was May 15th. Then I send the bills out so that they get first due date of June 15th, the second one of July, and then so on until they get the penalties added.
And then my understanding is you're saying that at the time the second payment on this property was due, you would have been happy to apply the money you had.
Right, which
To
we
that.
do. That's what I do.
Which is what you do.
Correct, especially if
but-
taxes are due.
But he indicated that he had to have that money in order to pay the lenders.
Correct. He wanted that reimbursement because he assumed, like he said, well, we were wrong because we billed him for it.
Yeah.
But then I was like, well, do you have the second one open though? So he said, no, I'll deal with that. I'll take care of that.
So as of now, there are no administrative proceedings pending on this property regarding the tax, is that
At
correct?
this point, no. Other than.
There was no application for redetermination because
No,
he
there was no appeal on
recognizes,
tax at all.
he recognizes the tax is due.
Yeah,
Okay.
yeah.
When do you first
Thank
remember
you for
talking
coming.
with Mr. Gabay about this situation?
Like I said, I think somewhere between November and December.
It wasn't in August or September?
No, we took his payment in August, I believe. But again, that's staff that takes that. I just remember there was an issue. He did come around a couple times because he wanted that money back. So I do
When,
remember
and
that.
the earliest time you know that he came to ask for his money back?
Couldn't give you an exact date. I don't know.
Month?
After August? Possibly, yeah. But again, it would be pushed out of my office at that point. He wouldn't come back to me.
Do you remember ever offering to transfer the credit over to the other?
Not until the
property?
bills went out.
Pardon me?
Not until the second installment of bills went out, which was November 15th. But we didn't meet until December 1st
Okay, so in
about it.
November, you did tell him it was okay, that you would have been able to transfer the credit over, and he,
That's why I don't think it was an issue. I don't know where it was at that point, because we weren't talking about it at that time. It wasn't until December we started talking about that.
But at that point, you made clear that you could transfer the funds over.
Yeah, I'd be happy to.
Yes.
Yeah, that's
Yeah.
what I do. So, but the thing about the cannabis, it's a unique circle that we're all in. I have my area to take care of, Peter does, everybody has their own thing. So even though it'd be great if I could say, sure, okay, it was paid in error, but I can't determine that. You know, if there's a bill, I have to collect it as a tax collector. So,
What's the process for getting a refund under circumstances that he was in?
it had to go in front of the board. There were three or five items that were special like that were different, because like I said, I would apply it if I had a, outstanding bill. So it went in front of the board.
Okay, so he finds out in late August or whenever that he's paid the tax on the other parcel when he didn't have to. So does he come to you to try to get a refund first? Is that what he did?
Well, because he paid me, he started with me.
Okay, and so what did you tell him to do?
He had to go back to Peter because he's the one that told me to bill him.
Okay.
And that's
And
the
so he
confusion.
goes back to Peter, and you find out then that he shouldn't have paid the tax, is that right?
Right. Apparently,
Okay,
yeah.
when was that?
I don't have the dates in front of me. I don't know.
Was it like September, October?
I was going to say, at least beyond middle of September on. But I just don't remember the involvement with him too much, other than telling him I couldn't do it until we had to actually try to give him the refund because he kept pushing.
I think what we're trying to find out is the date, as close as you can. Tell us when you realized or agreed or were told that he didn't have to have paid that money, and therefore... he
I never
should have
told him he
gotten
didn't have to pay it.
Pardon me?
I never told him he didn't have to pay it. I couldn't give him a refund, is what I told him.
You could give him a refund?
I couldn't,
Couldn't
no.
give him a refund? I thought you'd said that, okay.
No, I thought you were talking about the second installment, applying it to that one?
no,
Yeah,
right
I know,
now.
you probably shouldn't involve me, huh?
No, I think,
Okay, let me try this again.
Let's do this. Peter, do you remember
think
when you
it's-
told her it was okay, that it needed a refund?
All this was done over the phone, so there is no written record of what happened. My recollection, it was late summer, early fall, so it might have been September.
Same as
I know
hers.
that he paid it in August. It was sometime shortly after that we recognized that, he shouldn't have been on the list. I had indicated to Barbara's office that that was an error. But we didn't have a procedure in place for correcting that error. This is a new tax. We didn't really have a procedure. There was sort of back and forth, and we were sort of talking apples and oranges. I was saying, well, the treasurer tax collector collected the money. They have to refund the money. I don't have the money. They have the money. But it was our decision to decide that Mr. Atal shouldn't have paid that. And so I said he shouldn't have paid. And so then we were trying to work out, well, how do we authorize the refund of the money? I think that's what Barbara was trying to work on during all this time was, working with the admin and figuring out the process to refund a tax bill that was issued in error.
Ordinarily, when Barbara sends out a tax bill, that's a debt to the county that can't be discharged by anybody but the Board of Supervisors. There is a provision in this section that dealt with overpayment. And when there's an overpayment, then a person can either get a refund or they can have that amount of money credited to a future obligation. That's how we ended up trying to treat it as. We said, okay, he owed nothing on this one that was erroneously billed. Therefore, he made an overpayment of the sum that he paid, whatever that total amount was. Therefore, it actually says that it can be the person can claim a refund or take a credit against taxes collected and remitted for future obligations in a manner established and prescribed by the tax collector. And so Barbara's obvious preference is to, if I recall correctly, was to credit it to the future amount due, because when you, the bird in hand sort of philosophy of tax collectors or debt collectors of any kind. This person owes me money. I don't want to give them money back. But Mr. Gabay was under obviously substantial external pressure to get that money and pay back someone else. And eventually, as Mr. Gabay described, his supervisor, Mr. Garamendi, got involved, and he exerted pressure and, on all of us to make this refund happen, and it happened. And so to me, all of these external factors are sort of extraneous. The fact is there is a second installment due, and it wasn't paid.
May I ask Ethan a
Yes,
question?
yes.
Either you or Peter, I think, said he was on this list, or the first property was on this list erroneously.
Yep.
And that was the reason he got the tax bill, is that correct?
Correct.
And when he asked about whether he needed to pay that tax bill to I assume the tax collector's office, he was told, it's on the list, we need to collect it. So if we're talking proximate cause here, the error of putting him on the list led to all this problem. And so that although it was his choice to take the money back so he wouldn't lose this property, instead of having the money credited to the second payment, that situation would not have arisen if the first property had not been on the list erroneously.
Okay, in response to that,
Please do.
I would say that, okay, you get a tax bill that you know, or that even if you just suspect, hey, I thought this was denied, I shouldn't have to pay this. What you then do is you appeal that tax assessment to the CAO. That's the process for appealing an erroneous tax assessment. And Mr. Gabay didn't do that. So this situation was rather unique because we decided, okay, well, hey, look, we recognize there's a mistake. Despite the fact that he didn't appeal his tax assessment, we should unwind this. And the solution that we initially arrived at, and correct me if any of this is incorrect, was that we'd rather have Mr. Gabay's overpayment credited to future obligations. And obviously, Mr. Gabay didn't agree with that approach, and he faced extreme external pressure to get that money back and pay it to a third party. And so, I mean, it's unfortunate that it happened to Mr. Gabay, and I recall him being under tremendous pressure at the time, and that led to us eventually remitting the refund.
There's a timing question on this I'm not quite sure I nailed down. According to the applicant's testimony, that need to get the cash as opposed to a credit really didn't happen until December. And before that, he would have been okay with getting a credit, but it was just bounced back and forth, and nobody would give him the credit until December, and then it was too late. He's already into foreclosure, and they'd run up another XYZ dollars, and he had to have the cash to save the property.
Yeah, well, Mr. Gabay, I'm sure will have his own rebuttal and disagree with my characterization of this, but I find it very difficult to believe, and Barbara's here too, that she ever would have told him she wouldn't do that. I mean, at any given time, she would have credited him. This commingling business is not something I had ever heard of or would have imagined coming up. Barbara, correct me if I'm wrong, would have at any time said, hey, yep, no problem, we'll credit this to your future obligation.
Okay, I thought she did say she wouldn't give him credit, at least at first, because she'd never heard of it before. And I may have misheard her. If I'm wrong, please tell me I'm wrong.
Again, like the timing is important, like you're saying. Yeah. In December, the bill was already out. The bill went out November 15th. Right. So that's when I was getting involved with applying it. So I would have applied it.
Okay.
Yeah.
Except something happened back earlier, 2 months. There was contact
Well,
with your office.
he wanted the money back
Yeah,
because he knew he was denied, apparently.
but he didn't agree at that time to give him the
Well,
credit.
I will not. If the bill's active, it was not told, you know.
See, I think that's a different statement than what Ethan's.
I think maybe what part of the confusion is here is that in September or October, there wasn't a bill due yet.
Right.
And so not until
Yeah.
November 15th was there anything to apply as a credit against a potential future one.
He had it, yeah, he used the term future, so.
But it also could have been possible that his application might have been denied for some other reason before that date, in which case there wouldn't have been a tax bill due on November 15th.
But if it could be applied to future credits under the Measure C, it could have been.
It could have been, yes.
Okay. So your brain's hurting. We see
You know,
the
I'm
wrinkles.
I'm not getting this very well.
I know, I'm not getting it very well either.
Why was he paying his taxes in August anyway? Aren't they due like June?
Well, they were due June 15th. There was a penalty, a 5%, 2% penalty, whatever it was, 10% penalty at, if it was paid after June 15th up until, I think it was July 15th, and then after that there was a 20%. And so we still need to collect the money. They were just late, so he paid the late fee. That was the additional $4,000 was the late fees that he was
And
paying.
when was his first property denied?
His-
December 2016.
December 2016.
Before Measure C was looked at, I should have never gotten that bill. And had I paid the tax in August, I would have to pay unnecessary interest.
Can you get up to the mic, please? Thank you.
If I had paid in August or September or whenever it was that they decided before the tax bill, that would have meant that I would have agreed to pay extra unnecessary interest to the lender when I could have satisfied that debt, got the bill in November, renegotiated terms, not have paid all that extra interest over time, and just satisfied the tax bill.
Did you come here prepared today to pay this bill?
I could, a check right now, I don't have a check right now, but I could make an effort to pay it right away immediately, yes.
And how would you do that? You don't.
I would have to get money, but it wouldn't be an issue like a lengthy time. I wouldn't need a crazy amount of time. I just cannot do it out of pocket right now, but I will be able to pay it.
How long?
The amount, whatever time you would get, I mean, today, obviously not, but I would probably, by next week. It's the end of the week. I can't imagine anything happening overnight. I would just need a few days to work out some terms and then pay it by next week.
Okay, so I just want to back us up just for a second because I can see where you guys are leaning about going. I don't think we have the right to overrule on that. If they're telling me administratively it goes to the Board of Supervisors, do we have the right to rule on that and change when he can pay his taxes?
No, I don't think that's the issue.
Okay.
The issue before us is whether or not the application was rightly denied for non-payment of taxes. What I believe Mr. Gabe is saying is the extenuating circumstances associated with the county of holding on to the money that was paid for, that need not have been paid. I'm not going to necessarily say it was paid in error, but it need not have been paid, and the length of time it took to refund that money created a situation where he was unable to pay the tax, the second installment, in a timely manner before we took action to deny it.
As I understand it, I mean, we have no jurisdiction to determine whether tax is due or not, but we're not required by Measure C to deny the permit if the payment is late or not made. Is that kind of council's understanding?
Right. I think Peter stated it fairly well. What's before you is the denial, the planning director's denial of the registration based on a failure to pay the tax. What's not before you is the amount of the tax, whether it should be paid, when it should be.
No, I understand that, but my understanding is though, since, I mean, Peter's letter saying that's fully due, and if you don't pay,
I'm denying it right now.
May be
No,
denied.
it doesn't say.
It may be.
May
Correct.
be denied, which is what we established earlier. So that presumably, it can be sufficient grounds. We have before us a non-payment of a tax that's fully due and payable. It can be sufficient grounds for denial. It doesn't necessarily, we are not bound to deny, and the planning director is not bound to recommend.
What Mr. Laddish said is absolutely correct. Chapter 3.56050 says that failure to pay tax after demand shall be grounds for denial, but then the basis of the denial is 17.95170, where Peter may deny for violation of a local statute, and the local statute was you got to pay by December 15th. And then chapter 3.56040 says that it shall be grounds for denial, but Peter doesn't need to make them grounds for denial.
Okay. Just to let everybody know where I'm headed right now,
So let's not do that yet, because I think we need to
That's
go to
fine.
public comment.
oh, sure.
Okay.
Now, I got a couple of questions here.
Should I sit?
All right. On the tax bill that you get on this parcel, total tax is $44,000. First installment's $22,000, second installment's $22,000. Now you learn in, let's say, late August, early September, that you need not have paid the tax on the other parcel, correct?
I didn't have to pay taxes on which parcel?
On the one you got denied the registration on.
Right, around that
So
time.
the county owes you,
$26,620.
all right, now were you given the option in late August or early September to have the refund money that was due back to you applied to the second installment on the parcel that we're talking about here?
At the time, like Barbara was saying, there wasn't any protocol of how to refund. So at that time,
Now, I'm not talking refund. I'm
Oh, so
asking
what?
credit. Were you given the option to
no,
apply?
no, I wasn't even. That wasn't even a question because I was
Right.
not supposed to get a refund.
If you had been given that option and you had agreed to have part of your refund, $22,000, credited against the future installment that was going to come due in November, would you have been okay with your lender and so forth?
This is in August, before the
August,
bill was due.
September.
If I agreed to that, I would have had to pay extra interest unnecessarily because I could have just said, here's your money back, and then waited until October, November to start new terms, so I wouldn't have to waste $2,000, $3,000 just to not get that money back.
All right, so had you been given the opportunity to have the second installment that we're concerned with here wiped out, if you will, by crediting part of your refund against it in September, you would not have taken that option, correct?
If they told me in September, you're going to lose your license, if you don't, just like they're saying now, you would lose your license, I would have no choice and say yes. And
Not talking about losing your license, talking about would you have taken the option to have part of your refund, $22,000, applied to the installment that was going to come due November 15th? If you've been given that option back in September, would you have taken it?
if that was my only option, yes.
No. An option.
If it's an option and the other option is to wait to pay when it's due, I would rather not pay extra money and pay it when it's due. But if you're saying to me, if at that moment you either pay this money now or you risk losing your license, absolutely I would be paying it at that moment because I would also have 6 months or whatever time to figure out a payment plan with the lender. But given the circumstances of when I was asked that, it was at the end line. It was end of December when they requested that money be transferred. I would only have 2 weeks, to come up with that money before foreclosure proceedings. Had I gotten the money, this is, I guess the confusion is, I borrowed money to pay taxes. If I didn't have to borrow that money, I wouldn't have to pay every single month an interest or any late fees. Come the time when I'm supposed to pay it, I could have easily got the same loan I gotten before and paid the taxes on time. The only reason I didn't pay it is because the money that I was supposed to pay was in the tax collector's hands. And I couldn't use that money, I couldn't do anything with it. Had I gotten the refund in August or September or as soon as it was supposed to, but I understand Barbara, she couldn't because there was no laws or whatever it was at the time. But because of that situation that was not in my control, I suffered the loss of a license that I spent well 6 figures on, just because of an error in the county that I had no responsibility for, I had no association for, but I'm getting penalized for it.
Now, when time came in late December of last year to for you to finally get the refund, did you tell Barbara that you would be making the second
Yes,
installment
I
payment?
did.
And when were you planning on making that?
I had said to her that it would take me, I wouldn't be able to pay it on time, and she said she understands. She can't do anything with the late fees on both the property tax and on the cannabis tax. That's not in her control, and I understand that, and that was it. And then I went my way, and then I got the refund after that.
Okay, when was your
Basically,
application denied here?
there's an exact date, in March, sometime in March.
March 14th.
Yeah, March 14th.
March 14th, and then you had a letter in January 23rd saying, and effectively, if you don't pay the tax, you may find your
Right.
registration. So, and what was the reason you haven't made the tax payment or didn't make it by March 14th?
I didn't have the money. I would have to pay, as soon as I got that money, I had to pay almost $10,000 for no reason other than the county had to figure out how to refund my money instead of refunding it and then figuring out the laws afterwards. So because of that, I accumulated more debt, paid back that loan, then I had to come out of pocket on top of that. That took me a few months, and now that it's finally paid off, it's too late to pay the county because they won't accept payment because of the denial. Well, they would accept payment, I'm sorry, but now that we have this, I just wanted to either rescind it, which is why I spoke to Peter Maurer, and he told me that there's nothing he could do on his end. It would have to be heard today. And if I go back and I got that money and there was no error, the taxes would have been paid and we wouldn't be here right now. But because of that situation, that's why we're here now. It wasn't because I got the refund and then you still didn't pay it. I didn't have the amount of time. It was an error or whatever, a mistake or however they want to word it, but I still never got that money back. I still was put in a situation of more debt for a mistake, and I never went to the county and asked for the money for the mistake that was made on their part or the time being. I just continued paying it, understanding that I would be able to pay it late because of the scenario that I went through. It wasn't because I had grounds of denial for any other reason other than my tax payment.
At the end of December, when you did get the refund, you were already late on the second installment, correct?
December 28th. I would have been late January 15th. Right? I think January 15th would have meant I was late.
That's correct.
The bill was due on December 15th. January 15th is when the first 10% penalty is assessed.
Yeah, bill was due
December 15th.
December 15th.
Yeah.
So at the time you got the refund, you're already owed the 22. And you told Barbara you'd pay it.
Right. No, that's not true. December 6th is when we had that conversation. And it's an email as well that Barbara sent out of when. This was before any debts were made. I received the check only after that was already, I got it December 28th.
Okay, got it.
And I have that email as well. If you want to look at it.
Okay. I'm gonna go to public comment now, if it's okay with you, because we're repeating again. Is there anybody in the audience that has public comment on this?
Hello, Planning Commission. Trevor Whitkey, Calaveras Cannabis Alliance. Ortal's my neighbor. He's a good guy. As all of you know, he had another property that came up for denial in a hearing, and as has been part of the discussion, he paid the tax on that denied property. And I think he's done everything to make a good faith effort to follow the rules and comply with all of the regulations. Mistakes have been made. People haven't necessarily been able to stay in compliance. They've gotten denied for various reasons. But I do think that Ortal, of all of the different people that have set up operation in the county, has repeatedly demonstrated an effort to comply with all of the regulations. He has stayed in communication with county departments. He's email records to back this up. He's doing what he can to try and show a good faith effort to follow the rules and regulations. There are issues with this denial. They've been brought up in other cases. I know Adrian Lambie has brought up questions regarding the county's interpretation with as it pertains to the survivability of the urgency ordinance, I know it's the county's interpretation that the urgency ordinance continued for 90 days after the adoption of the ban and after February 14th, 2018. I don't see any authorization statutorily under Government Code 65858 that allows an urgency ordinance to continue without authorization past the date that it's sunsetted. As far as I can tell, if you look on the Government Muni Code, there is no 1795125 A, B, or C. Those are the statutory codes that Maurer's decision is based on. He can deny people their applications and their registrations based on 1795125 ABC. Now, I pull it up on my phone and look at the Calaveras County Muni Code. There is no 17.95125. I believe it stops at 1795.060. There is no legislative authorization for the activity that is for this denial anywhere in county code. There's no authorization for extending an urgency ordinance for 90 days after an urgency ordinance has statutorily sunsetted. So, there's no basis for this denial. Furthermore, as I understand, urgency ordinances are limited according to statute in terms of time and scope. The time has sunsetted for the urgency ordinance. It ended on February 14th. I know the county believes that the 90-day automatic termination provisions that are contained within the urgency ordinance and within the ban ordinance is the basis on which they're interpreting an implicit urgency or an implicit survivability of the regulatory program. I don't think that's going to hold up in any court. I really don't. And I think that anybody that's been denied after February 14th has a really solid challenge to say there is no legislative authorization. They also have a challenge to say that funding that was used for the denial, for any of the continued regulations that have gone on after February 14th and that are being taken out of the MCCRP are actually misappropriation of funds. There's no legislative authorization for that expenditure. The urgency ordinance ended. And the notion that because an automatic termination, that means in absence of regulatory action, the permit will be denied automatically. In the absence of a regulatory program, my permit gets denied 90 days on June 9th.
I hate to interrupt you,
Yeah.
but Annette forgot to set the clock, so I started watching mine, and you're past your time.
Cool. I appreciate your time. Thank you,
Thank
Lisa.
you.
Thank you, Chair, everybody.
Okay. Any other further public comment? Okay, I'm going to close the public comment, and I'm going to bring it back. I know we've rebutted this several times, but I did public comment, and you get one last chance to rebuttal. Ben, Peter? Nobody? Okay. Do you have anything to say about your public comment? Okay. Then I'm going to close the hearing. I'm going to bring it back to the commissioners so that they can get more confused and talk it over.
Oh, I'm not confused a bit.
Okay.
I think we provided a model for a solution this morning. I would not have a whole lot of trouble with this case except for the fact that if the first property that's not before us today had not been put on the list erroneously, the 20, well, I guess it ended up being 26,000, but the tax payment that eventually was returned would not have been collected. And from that, very hard choices had to be made down the line. I understand the delay in the county in trying to figure out what to do under these circumstances. But on Mr. Gabet's assurance that he could get a loan to pay the tax at this point, I see no problem arising to the county under these very special circumstances from our, would you believe it, continuing this matter for either the next hearing or till May 20, well, whenever it was, to see if Mr. Gabay has received the financing and has paid his tax, and consider the situation at that time, or if the planning director wishes to withdraw the denial, then we wouldn't have to hear it at all. But that would be fully the planning director's discretion. That's my suggestion, because I think Mr. Gabay has, clearly these taxes are due, clearly he has not paid them, but this is all arising from the county making an error, putting it on the list, the first property on the list where it shouldn't have been.
Commissioner Pacelli?
I agree with Commissioner Lyles.
Okay. Commissioner Sisk?
I don't, I agree with the county.
Okay. Commissioner Wooster?
Well, I'm having a little difficulty here. It's actually a couple of ways that where the county could be criticized. One was the placing this property on the list that Mr. Laddish referred to. The other is there apparently was not a procedure in place to accomplish a refund in a timely fashion for months. And had either one of those matters been different, in other words, no incorrect notice in the first place that a tax was due, or had there been a timely refund, procedure in place to make it happen, we wouldn't be here, apparently, according to Mr. Gabay. That having been said, I mean, the other problem here is an apparent financial inability to pay this tax when it was due, and that's not the county's fault. When we get to January and February and all the way into mid-March, and there's still no payment due. And, you know, the county did have the money. It could have, maybe should have simply said, we're going to apply it whether you want us to or not, against the second installment. So I think I'm reluctantly leaning towards denying the appeal.
Okay. I don't think I'm in a position to overrule the tax collector and the code on the ordinance. If you don't pay the taxes, that you get a denial. I think that we're overstepping our line. I think that if the things that took place took too long to get the money and he had damages because of the situation that did occur, that's a civil issue. That's not an issue before me today that says he didn't pay the taxes on time and therefore didn't qualify, and he got the denial. I mean, I sympathize for the fact that, okay, that money was out there, but he was going to have to pay these taxes anyway. He was still going to have to pay the mortgage anyway. So it was being financed out there and tumbling down, which I don't have any control over. The only thing that I can do is look at the ordinance and say the taxes were due, and the ordinance states if you don't pay them, there's a penalty, and it still has to be paid, and you lose your registration.
But it doesn't say that. You may lose your registration. We're not stepping over the line. We're making a decision whether he should have his registration
Read
denied.
that again, please.
Sure. The basis of the denial is fundamentally 17.95170, which is denial for violation of a local ordinance, and then that refers back to 3.56040, which allows non-payment of taxes after demand to be grounds for denial. So there is discretion exercised here by the planning director, who made the decision to deny the application for non-payment after demand.
Okay, so if we move forward with the shall part, the may part, the we could part, we are setting a precedence all the way down the line.
We're following the statute. What we have to do is make a decision. It's a hard case, and I was being flippant when I said it's easy for me. It's a hard decision to make, but we must make the decision on the basis of the law, which means we have the ability to either grant or deny or work out this appeal in a way that everybody has their money and has their permit. But we can't take the action on the basis of we have no choice here, we must deny the appeal. That would not be valid.
So does anybody, because I think Barbara left here, does anybody know if I overpaid my property taxes and I appealed it and wanted a refund, what is the statute and the time frame for being allowed to make those refunds? Does the county get a month? Do they get 90 days? Do they get 120 days? What is the statute for getting a refund on taxes? Nah, we're not going to do that and cause more confusion.
Yeah, Measure C had its own procedure for overpayment, and it's when you make an application for. What was that, Trevor?
It's 3 years.
Three years? Oh no. Well, you can get a refund under 3.56 upon making a written request if you've overpaid your taxes. And then it says that this is extremely obtuse language, but it says a person licensed to engage in commercial cannabis activity may claim a refund or take a credit against taxes collected and remitted any amount overpaid when it is established in a manner prescribed by the tax collector that a refund is due. And that's the way we read that when I was working with Barbara on that is that she could either credit the money due to his second installment or provide him with a refund.
So there's no time frames of when the county would have to perform on a refund, on an overpayment?
No, it provides no time frame. Oh, the request for the refund has to be submitted within 3 years. Perhaps that's what Trevor.
Okay, so the request, but
Yeah.
what is the county's liability to give the money back? I mean, they have none, they could be open-ended, and they could have sat on his money for a year?
It doesn't say.
That just irritated me, I'm sorry.
You should spend more time with Major C then.
Oh, man, okay. So we're starting a whole new world here today, you guys, because these are the first major Cs that I've sat in on. Maybe you sat on them a month ago when I wasn't here, I'm not sure. But we need to make decisions that are going to be clear-cut going forward, because most of the appeals coming forward are going to be based around this. We can see that that's happening today. And these are the first cases we're getting, so we need to make the right decision.
I doubt that we're going to be getting many more cases where property was on the list erroneously and thus prompted a payment that then was not returned when the error was discovered, which created a foreclosure situation. I just don't think this is the first of a long chain of similar cases.
But the county didn't create his foreclosure thing.
They caused it by having the property on the list erroneously to start with.
Okay, but if you're going to say that, then you can go around and say that it was only on the list erroneously because he had another property that he was trying to run a business on. So it's,
Okay, hold on. Thank you.
he had a license, he tried to get the license, he did his permit to run on another property. When that property got denied, or he was no longer growing on it, and he got the bill, it is kind of his decision to appeal that bill, and he did not do it. He paid it.
We're not going to criticize him for paying taxes that he's told is due because the property's on the list.
I would have panicked and paid the bill too. I'm going to say that.
When the county has put this property on the list, He's being confronted with a situation of the county.
How many
Well,
months did the county
erroneously,
have his money, and how many
we admit it
months?
was erroneous. So
How many-
I'm sorry.
How many months did he ask for his money?
I don't know the answer to that. Mr. Gabby can answer that, but I know he was paid, I believe it was sometime in December, and I don't know when he initially made the payment. It was initially due back in June, but I'm not sure when he paid it. So it sat on it between whenever he paid and sometime in December. when
And
it
he
was
paid a
issued.
late penalty on that?
Yeah, he did.
Yeah, he did.
He stated that he paid it in August, and it included the late penalty of $4,700.
October, November, December. So the county had it for about between 90 and 120 days.
That could be right.
My suggestion, the county gets its taxes paid. Mr. Gabay has avoided the foreclosure on his property, and I don't think we're setting a dangerous precedent at all. And we're not overstepping our jurisdiction.
If anything, I think Mr. Laddish's approach would foreclose, pardon me, so that would, any further damages being suffered by the applicant, so. I'll stop at that point.
Oh, you sure?
Hint,
Okay.
I'm looking past you.
Okay, so here we are, and we either need to make a motion to uphold the appeal, deny the appeal. Do you want a 10-minute break to process, or do you want to just, let's vote?
I'll like a 10-minute break.
All right, we're going to take a 10-minute break. Okay, now we're ready to come to order. Okay, so we are still on appeal number 2016803, and we are at the point where we have closed the hearing and we're in deliberations with the commissioners, and I am looking for a motion.
I move that we continue this case until May 25th.
Mike, please.
Oh, I move. Echo chamber.
Now you can move.
I move that we continue this the hearing on this appeal until, I believe it's May 25th, is the
24th.
24th, in order to give Mr. Gabay a chance to get a loan, in order to, or somehow, find the money to make the payment to the tax collector that he is in arrears for, including any late fees, et cetera, and that that continuance, hearing on continuance, is also subject to the discretion of the planning director's decision to decide whether or not he will rescind his denial of the appeal because of what has happened between now and May 24th.
Okay.
And that's without any pressure on the planning commissioner. I understand it's what you
So,
need.
why are we going all the way to May 24th?
Well, if,
Well, in order to have something brought back to you on May 10th, we basically have to have the packet ready tomorrow. So,
Can we set a deadline of payment?
well, I think that by May 10th, if we have not had anything, we would prepare a report for you saying that we would, continue to
Okay.
recommend denial.
right,
And is that with the option to not come back to a meeting?
Yes.
yes.
I'll second the motion.
You're going to second the motion that he has till May 24th?
Yes.
And did you want to shorten up the time frame for payment? Or you just
Oh,
motion
I
as
can-
is?
No, May 24th.
Okay. So are we ready to vote? All in favor, say aye.
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 Opposed?
Oh,
No. Okay, so it fails 2-3. Would somebody like to reword the motion?
Well, I'd be happy to reword it for an earlier payment. If
Okay.
it's going to get us anywhere.
I would to uphold the planning director's decision.
Was that a motion?
Was that a motion?
Yes.
Okay, is there a second for that?
Second.
Okay. All in favor, say aye.
Aye.
Opposed? No.
No?
Okay, it fails again, 2-3.
I've got a motion.
I don't know if I trust you.
Got a notion for a motion.
Okay.
That this matter be continued until May 24th on a basis that Mr. Gabay will make his payment to the tax collector by May 10th, and that the planning commissioner, if that such payment is made,
Planning
planning
director.
director, if such payment is made, will have discretion to either withdraw his denial, rescind his denial, whatever the proper word is, or let the matter come to hearing on the 24th.
And does May 10th give you advertising times and you're good?
Well, it's continued to a date certain, so we would not need to re-advertise.
Okay, good. Okay, so is there a second? All in favor, say aye. Aye. Opposed?
No.
Okay.
We got
Motion-
3 yeses?
Motion carries 3-2. Okay. Do you understand what you need to do?
There was a lot of different dates.
You have to make payment by May 10th. If you make payment, Peter can decide whether or not you're coming back before the commission. If you do not, you'll be back here May 24th. Okay, thank you.
No,
No?
no, the motion
No.
I understand, that needs to be, it's been continued to May 10th.
No, we continue to the May 24th.
We can
Payment by 10.
Payment by May 10th.
We can't,
Okay,
add-
okay.
okay.
Okay,
And if he makes the payment, no meeting.
Not-
well,
No.
that's my choice.
If he
Then
makes
it's,
the payment,
It's up to
the
Peter.
planning director can decide whether or not he still denies or,
So by May 10th, it has to be paid in full, or can we do partial payments like you have been, until the 24th to pay in full?
May 10th in full.
I think under these circumstances, yes.
Okay, so, next hearing, I want to do something real quick, if everybody will bear with me for 1 second. We had a hearing earlier for Leah Luttrell, which was 2016-789. She was not present. We were returning from lunch, and we were opened and closed by 1:05. So she came in the door right after we voted. I would like to know if you guys want to give an opportunity to reopen the hearing so that she can be heard.
Before we do that, I want to make sure Mr. Gabay is clear on what.
He can go to the planning department and get all the
all
information. We've
set.
got more work ahead of us.
Okay.
So, the question, that was a question.
I'd be happy to let her, I guess we'd have to reopen.
We would reopen the hearing.
And- But when we've done this before, we've had the person look at the tape of what the planning department presented so that we don't have to repeat that now. So I would suggest that if we're going to do this, and I'd be open to it, that she be given a chance to look at the previous hearing on the video.
Well, as I recall, I think the presentation was all of about 30 seconds.
Yes, it was.
So,
just make the presentation again.
Yeah.
I think that's much more
If
sense.
it's your inclination to allow the testimony and reopen the hearing, I would say let's just do that.
In light of the number of cases, I wonder if we could just simply move her to another hearing date.
We only have 2 left.
3
3,
or 4, don't we?
4, 1, 2, 3.
there are 3 other matters on the agenda.
Yeah, we have 3 left.
She has been here all day with her children. It's up to you. I know that we have allowed other people that, for whatever reason, missed their allotted time to come, to be heard.
Well, I would ask that you be dropped to the end of the calendar.
I think that's a good suggestion.
That's what happens in the big boys' court. So.
Okay, so I would like to poll each of you.
I agree that we should rehear it, but I agree with Commissioner Pacelli.
That's fine.
Put it at the end.
That's fine.
I think that we should hear it now. She's got small children here.
Oh, those are her
Now you
children?
tell me.
Well, as chair, I kind of let you guys lead the way. I'm just telling you, she does have small children.
Then you need to give me 5 minutes to go get my paperwork, because I already put it in the trunk of my car, because I thought we were done with the first half of the day.
Okay, so we will hear it, what's this next hearing, is it?
Self-employed. Obviously, we're full-time commercial farmers, so we're self-employed. We'll come back if that's what has to happen. We just want to make sure we.
Okay, we're going to have one hearing, and then you're going to be up. So in the next 15 minutes to 30 minutes, you'll be up.
Thank you for being patient over there. So
Okay.
they're going to go home and tear our house apart.
Okay. So
What's the number on that one?
that one is 789.
That's what I mean, when we hear it, I have to go outside to get it back out of my car.
Okay, sorry.
That's okay.
All right.
Make your payment at a time? Full payment?
Okay, so we're going to open the hearing on 2016954. And this one is for Kenneth Wright. Is he present?
Would it be possible to come back on another day for hearing due to the length of the event? It might be easier or
Can you come to the mic, please?
can we come back for another day for this hearing?
I think we'd like to just hold it right now because the other person isn't even present. So if you're available right now, why don't you go to your car, get your paperwork, and we're going to do it now, and then we don't have to come back.
Okay.
Okay, it'd be easier on you with the children. You won't have to come back and sit.
Thank you.
But
Quick recess?
yeah, just quick recess. So now we're going to call the meeting back to order, and we are going to open the hearing for 2016-789. Karen, are you okay over there?
Yes, ma'am.
Got it? Okay. So I'm going to give you your 30-second presentation again.
This is Appeal 2016-789 by Leah Luttrell. Pursuant to Calaveras County Code Section 3.56040, all individuals engaged in commercial cannabis activity are required to pay the commercial cannabis activity tax. And as of March 12, 2018, the appellant had not, and as a result, her application was denied.
Okay, thank you. Any questions? Okay. Mrs. Luttrell, would you like to come up? And you get 15 minutes to present your case.
Okay. So I applied for the payment plan for the taxes, but due on the date March 1st, we were at the property, and due to the severe weather, it caused the roads to be undrivable, couldn't get in and out. And so, and then another obstacle we overcome on Maranatha Lane was a tree that fallen over, so we were blocked in. So it was impossible to get out of our roads that day to make the payment, have the payment. I contacted the tax collector's office the following day, informed them of the obstacles that we occurred of not making it in that day, and they said that because it was March 1st, they're not able to accept the payment plan no longer. It had to be full payment in order for us to still under be the ordinance, okay, or without being denied from the planning department. I'm not able to make the full payment. That's why I was hoping to do the payment plan, but due to the weather conditions, that's why I put the appeal in, because I feel that it was out of my control due to weather conditions and the road conditions. We couldn't get out. We were stuck.
So were you going to be paying it in cash? Is that what
Correct.
the deal was? Okay, so you couldn't do it on the computer?
No.
Okay.
Where do you live?
Copperopolis.
Okay, and so you do not live on this property,
No.
but both you and your husband were on the property?
Correct.
And at the time you arrived, what were the conditions, the weather conditions?
We were out there preparing for the rain to be coming in, doing erosion controls on the roads, because we knew that we're going to be having many days of weather coming up, and I did not realize the severity of the storm that was coming in that day. So it just made the roads unmanageable,
Do you have a trailer on the property?
Correct.
Okay. And who opened up the road? Is that a county road or private?
It's a private road.
So it's yours?
It's non-maintained by county. It's on Maranatha.
Okay.
So my whole appeal was hoping, so I was talking with the tax department, and I wanted to see if there's still opportunity or if they're willing to have any other options to go further with the payment plan. But they said because I missed that deadline, there's nothing further they can do.
I'm sorry, say that again, because what?
Because I missed the deadline?
Because you missed the first payment.
Correct. There's nothing further they can do. Although I explained I felt it was out of my control due to the weather when I'm doing everything.
Did you have the money with you?
Yes.
Do you still have it with you?
Not as of today, but yes.
How much are you talking about?
Well, the payment arrangements is like 6,300, something like that, would have been due by the 1st.
And that's first of what?
March.
Okay.
And so when I found out I was getting denied from the planning department, I contacted the planning department. Then I was aware, or they informed me of the appeal process. I explained to them the situation, what happened. They told me I need to take the tax collector, which I tried, and they didn't offer any other solutions. So they offered to or gave me the information of sending in for the appeal. And that's the decision we chose to do, or I chose to do, due to I felt it was unmanageable.
Well, just to be perfectly clear, we cannot change the amount of tax that's due or a tax payment plan with the tax collector. We're here to decide whether the denial of the permit application is appropriate under the circumstances.
Correct.
Okay. I just didn't want you to think we could say, your taxes are okay.
I'm fully aware that the taxes need to be paid, and I have every intent to pay it. It's just I don't have the full amount. I'm trying to stay under the ordinance, so that's why I did the payment.
First payment was March 1st, second would have been April 1st, third would have been May.
Coming up May 1st.
So in the next few days, you would have been
At my third payment.
18 grand or so.
Correct.
That's pretty close to the full amount.
Correct.
When did you make arrangements with the office to make payments?
When did I? February 28th, on the last day. I just found out a few days prior that there's a payment plan set up, and so that's when I called the tax collector, and she informed me that if I signed up by February 28th online and submitted that the first payment would due March 1st. And so that's what I did.
So what is the provision and who makes that? Is that in Measure C that there can be a tax plan? Who came up with that?
The payment plan was something that Barbara and administration and our office came up with to just facilitate more payments because there was many people who wanted to make them. Barbara wanted to have a manageable program that had a beginning and an end that was easy to track and manage, and payments had to be made March 1st, and then the total amount due had to be paid off by June 7th.
And was that approved by the Board of Supervisors, or was that an administration?
That was just administration and within Barbara's own office.
Okay.
And this was your taxes are due, but we're not going to do anything about it if you make this payment plan?
At this point, by March 1st, the maximum amount of penalties had already been assessed.
And those penalties are part of this payment plan?
Yes, that's correct.
It's just that people could afford to do that with it, but they couldn't afford to pay the whole thing in a
Yeah,
chunk.
the first penalty was assessed in January, second penalty was assessed in February, and then so by that time, the maximum amount of penalties had already been assessed, and everyone was going to pay their full amount through this plan.
So my question is, you have 3 payments due.
Mm-hmm.
Have you attempted to make any partial payments whatsoever to the tax collector
The tax collector won't take partial payments. It's full amount.
at all?
except for pursuant to this limited plan that was available beginning March 1st, and that's when everyone had to have their plan.
But they owe the
submitted
money
by.
no matter what.
That's true. They owe the money no matter what. But Barbara doesn't like to have to manage everyone's individual account. over
Okay,
a
so it
long
becomes an
period.
accounting issue.
Yeah, because someone could come in and say, here's $1, and then
Okay.
and then you have to manage that account. And it takes a lot of staff time
Got it.
to do that.
Understand.
So it was due in December. She had the opportunity to start paying it in March and make monthly plans, correct?
That's correct.
Okay, thank you.
You have all 3 payments?
Not as of today, but yes.
No,
Not-
if you
yes.
were able to come in tomorrow and see Barbara, could you make your 3 payments that were due?
In a few days.
The third payment is due in a few days, yeah. In, next Tuesday. The third payment would be due next Tuesday.
So what are you here asking us to do?
I would like to see if there's an option to get the taxes paid up to where I need to now and do the last payment in June and keep the approval, or not dismiss the denial of our application for the,
Okay, but you don't have the money to bring it up current.
Right.
that's something I would love to start the process on. I don't have,
Don't make promises you can't keep because it'll hurt worse later.
okay. Can I not respond to that right now? At this time, I don't know how much as of right now, but that's something I could definitely, if I was given like some type of timeline or length of so many days, then I can.
Okay, so if there's no other questions, do you want to hear from public? Okay, we'll listen to what the public has to say real quick because there's someone dancing in his seat back there behind you.
Are we good? Okay. You already heard my survivability argument. I think it applies here. I don't think that 1795125 A, B, or C is still on the county code, and therefore there is no authorization for this denial. There was no authorization for this denial at any point after February 14th. If you're going to make the denial, you're doing so in lieu of any statutory authorization. All of the arguments that I made earlier should be applied here. Other than that, as Ethan alluded to, Measure C is quite the ordinance. And what happened was there was very limited payment on the second installment of Measure C taxes, and only about $1 or $2 million had come in out of the near $8 million that had been sent out, and that was nearing the deadline in whenever the deadline was. I believe it was January, February. As a result, lots of people came in and requested an extension, requested a payment plan, requested some mechanism to allow them to stay in good standing and to pay their Measure C taxes. It was out of this time period that and totally pursuant to the code, I just had it up here, but basically Barbara Sullivan's office, the tax collector, promulgated rules and regulations to allow for the taking of the tax, and they created this payment plan. There's no memo. It was not publicly communicated to people that that this new form of tax collection was available. People like the applicant who has been denied was informed and tried to make a good faith effort within a very, very small time frame to get into this payment program. If it had been rolled out in a way that we actually knew about it, and people could have, when these tax bills were sent out, when the second installment was sent out in December, if people had gotten that tax installment and been told, oh, by the way, you also have a payment plan option, they could have used that time to get into the program. Instead, there was about a 1 week time frame. It wasn't well publicized. People tried to get into the program, and inevitably, as we all know, you're going to have situations like this arising because of our county. We have very Harbor Road's sometimes hard to get out of if one side of the road is flooded and the other side's got a tree down. And if that's the one day that you can pay the taxes, it creates a problem. It also says in here the taxes are supposed to be assessed and remittance is supposed to be taken like property tax. And it seems like this program is different than the property tax system. I don't think that we would deny somebody their property rights on the same grounds as are being denied here. So for the same reason that I made earlier, survivability, the urgency ordinance ended, there isn't any statutory grounds for the decision to make the denial, and the fact that this applicant is trying to make a good faith effort, and the only reason she isn't able to necessarily guarantee that she can provide $18,000 on the spot is because she wasn't allowed to get into the payment program simply because of a 24-hour deadline. And thank you for letting me probably run over my time.
No, you did fine. Okay, so I think that, is there any other public comment first? No. Even if it was short notice and it wasn't totally advertised, I think it was awesome that they offered it. I give Barbara credit for even being willing to do that because it's a lot more accounting for her. Yeah, let's go back to you. Do you have a rebuttal on anything?
Only that the taxes were due in December of last year, so the condition of a road March 1st this year isn't really here or there to me. So taxes were due, they haven't been paid.
In 3.56040, which is in this chapter, it says that it'll be grounds for denial of any permit or license that may be in effect at the time the taxes are due.
Read that again?
3.56040 is a statutory basis for denial of a permit. Mr. Whitkey indicated there was no statutory grounds in the event the urgency ordinance wasn't applicable. And even if it weren't, there's still grounds.
And what you're really saying is that the tax collector came up with a payment plan, and the planning director was willing to lay back and not deny a permit if that payment plan was met.
Correct. And there was a press release, and it was on Barbara's webpage.
Yeah. And it'd be interesting to know how, human nature being what it is, how many people pay their taxes on the very last day they're due. And
I'm not sure, but the total number of people that entered into the payment plan, I think it was 23. And so if everyone follows through on their plan, I think it'll be something on the order of $700,000 that'll be collected.
I do believe I remember the storm of March 1st. I certainly understand that if you hadn't paid before March 1st and you were on this property, that payment could have become impossible.
Okay. Do you have any rebuttal to what the county just said? No?
I got a question for you. Did I hear correctly that you learned about and applied for this payment plan on February 28th?
I applied for it on the 28th.
28th
The
of
tax
February?
collector, informed me to do it on the website. As long as they have that submitted on that day, then I can make the payment the next day, the first.
Well, until you found out about that, what was your plan to pay the tax that was due?
When I'm able to come up with the 25 and pay, that's the total that I owe. Because I wasn't aware of the payment plan until a few days prior, and I talked to the tax collector at that time. And then to see what that was an option, the payment plan was an option or not. And she informed me it was, as long as I signed up by February 28th and then make the first payment on the 1st. That's exactly what I did.
I don't understand what that's about.
They don't take no partials, or they just want the full amount.
But wasn't it due December and late on January 15th?
I got penalized twice, and I'm accepting that. And then, so unless I have the full amount, go in there and make payment until I found out about the payment plan, which is at the end of February. And that's when I signed up for it.
So the tax collector,
unaware of that.
administration, and my office met to talk about, now that it's been banned, what are we going to do about the taxes? And we recognized that there was very low receipt rate for the second installment. We, again, it was due in December. There was a couple of deadlines when, a penalty was assessed. But once you passed the middle of February, there was nothing beyond that that would compel someone to continue to pay the tax without us going through a collections process to go after that tax. So, we came up with this plan sort of at the last minute. We could just deny everyone out of hand, or say, well, is it important for the county to try to get that money? And we decided that it was worth coming up with a program, but we didn't want it to sort of go on forever. So we set some fairly strict deadlines. You had to have paid an installment and entered into an agreement with the county before or on or before March 1st in order to be able to participate in that, and then a commitment to pay the second and third installment of that payment plan on April 1st and May 1st. And that's what we agreed to, and it was sort of a last minute thing. It wasn't something that had been advertised. It didn't even exist up until about a week and a half before that deadline. But the idea here was to, come up with ways that people would pay the tax.
I have a question for the applicant. If you became aware of the program, you applied on February 28th, you had the money in your pocket on March 1st, why didn't you, and you were not anywhere near ATMs or whatever on the 28th, or on the 1st, why didn't you make the payment on the 28th?
I don't know.
Okay.
I did everything online and I can't recall exactly, I can't answer that, I don't know.
I appreciate your honesty.
Sorry.
You're telling us that this payment plan was done online completely? You didn't have to come in here?
No, did it online. That was the only way to do it. I offered to come in, and they said you needed to submit it online, because it needed to be however, that's the instructions.
And
Did
did you do this online from your home in Copperopolis?
I did it on my phone. I'm not exactly sure of my location that day.
Do you remember when you went out to the grow?
That was the Friday, or that morning, the 1st.
So you went out to the grow on McCormick Hill on the 1st, the same day the tax was due.
I was not aware of the severity of how the weather is going to be. Usually you get in and out, but it got pretty bad. We went up there first thing in the morning, early morning.
Okay. So I think if you're done with questions, I'll go ahead and close the hearing and bring it back. Okay. Thank you. You can have a seat and we'll discuss and vote and figure out what we're doing here. No comments?
Yeah, I'm not sure what to say. It's an unfortunate situation, but all I can do is wonder, did the applicant not see the weather reports? And my recall is that storm was predicted to be pretty heavy. And yet, maybe she was stuck. I don't know. No offers of partial payments after that?
Well, I asked that question and there was offers of partial, but they won't accept.
I don't think she said she actually offered. I think what she said was that they wouldn't accept it.
Did you offer?
When I contacted the
Can you come up to the mic just for one moment, please? I'm sorry.
Yes, for the payment that was due, yes. And she told me they're not able to take
That's what I
that
thought
because
you
they need the
said.
full amount because I missed the deadline on the
Okay.
1st.
That's what I thought you said. Thank you. Okay, so she did make an offer. Now what do you think? You have comments?
Well, this is a program that the tax collector's office and planning department set up that wasn't required to be set up, and they set the deadlines, and they set the rules, and I don't understand why the first payment couldn't have been made by March 1. She didn't get to the grow till the morning of March 1. And the tax collector's office is here between Copperopolis and Oak Hill. I mean, it just should have been made. I don't think there's much that this commission can do about it. This tax just did not get paid. In fact, it was due in full December 15th. There was no plan to pay it.
Okay.
I'm going to uphold my original vote and support the county on this.
Okay.
I agree it was due December.
I think I will as well, and I have to focus on Kelly's comment about going from copper to smoke. I hadn't thought of that. She had to draw it right through San Andreas, or could have.
And the reason they were going out on the property was because the weather was coming in. I understand once the storm hit that they couldn't get out, but I don't understand why the payment wasn't made before that. So I would vote to uphold the planning director's decision.
Okay, would you like to read the recommendation?
Staff recommends that the Planning Commission adopt Resolution 2018-031 as previously amended, thus denying appeal 2016-789, thereby upholding the Planning Director's denial of application 2016-789.
Thank you.
And your as previously amended is the amendments we've made to
It is.
similar cases.
Okay, motion,
So moved.
second?
I'll second it.
Okay, all in favor say aye. Aye. Opposed? Okay, motion carries, it uphold the denial.
This action is final unless appealed to the Board of Supervisors within 15 calendar days of today's date.
Okay, we will move to the next one, which is 2016954. And Mr. Wright, are you here or is there a representative? No, okay.
Right, this is Appeal 2016-954 by Kenneth Rayleigh Wright, pursuant to Chapter 3.56040 of the Calaveras County Code. All individuals involved in commercial cannabis activity are required to pay the commercial cannabis activity tax. As of March 20th, 2018, this individual had not, and unlike the previous cases, his permit had been issued already, so for failure to pay, it was revoked.
Okay. I was just want to take note of his letter here since he's not here. The planning department was incorrect to deny me because we were unaware of a payment plan. Paying $13,000 upfront without a payment plan was not possible considering the hardship we faced. Thank you, Calaveras Chronic, Ken Wright. Pardon me? I was going to see if the commissioners had anything to say. Nope. Okay, any public comment on this one? Okay, seeing none, I will bring it back to the commission for deliberations.
Well, I think it was great that the tax collector and the other agencies got together and came up with a payment plan, and if we get into just how well that was publicized, why we're going down a slippery slope. So I'm in favor of upholding the appeal.
Okay, across the board? Okay. Can you read the recommendation, please?
Wait.
What? You want to change?
No.
You have our attention.
Go ahead.
No, you said wait. We want to hear it.
Well, I'm looking at the resolution, so.
Okay.
So we would amend this resolution to match the others going forward that we made.
And just, after the 1, 2, 3, 4, fifth whereas, where it says, be it therefore resolved, the planning commission denies appeal by Leo Trell.
There's actually a
It's
typo.
got
Yeah,
Latrell's
you're right.
address also.
There are typos in the reso, you're right.
It's got the Moke Hill Maratha Lane address. Maybe the rest of it's wrong too. Is that the right APM?
Well done, Karen.
I
No,
believe
you
the
picked up-
APN
That's
is,
got all the trail stuff on it.
it does, it's incorrect.
Yes, that entire whereas needs to be fixed.
Okay. You can fix that later, right?
I can.
All right, we won't vote yet. We'll wait. You want us to vote and then he can fix it? It's, I mean, they're pretty minor fixes. They're just very impactful if they're not fixed. Okay, so,
I guess I made the motion, so I mean, my motion would be with the appropriate amendments as pointed out by Commissioner Zisk.
so just for the record, let's just identify real quick what we're changing on this resolution, please.
So under the fourth whereas, it would be the description of the property to reflect Mr. Wright's property, not the previous appeal.
Including,
Okay.
right, so the
And
APN,
then-
the address, and the description.
And then the name change under the therefore resolved, as well as the previous edits recommended by Commissioner Laddish regarding the tax payment requirements,
And then we're
and as amended by County Council.
Okay, and then we're amending all of these dates from April 26th because we're now doing the hearing. That's the right date. Never mind, I'm on the wrong day.
It is April 20th.
It is. I knew that. Wow.
That's the motion.
That wouldn't be Kenneth Wright, would it? Okay, so I have a motion and a second. Did I get a second? Yes. Karen, you seconded?
Sure, second.
Okay.
As amended.
As amended.
As amended.
And including the things that were pointed out.
And I'm completely
Commissioner
lost. Did you
Bocelli.
read that recommendation already? You did
I
as
did
a...
not.
you-
Oh, yes, you did.
I
Yes, you-
almost read that recommendation, but
And then Karen yelled, wait, wait, wait.
Yes.
Okay. You're up.
would you like me to read the recommendation?
I would love that.
Okay. Staff
Wait,
recommends.
wait.
I was saying, reading the recommendation isn't really necessary. I mean, it's in your document. You made a motion that says you are adopting the staff's recommendation, which is in writing. I think the reading of the recommendation is, more just for, clarity and, but we can go ahead and do that. But this, once a motion is made and it's clear what the motion is, it's not necessary to go back and read into the record what we were recommending.
That's not what I was taught. Now you're changing the rules on me.
But that's been our practice.
If you could go ahead and read it, then.
Go ahead and just read it.
All right. Staff recommends that the Planning Commission adopt Resolution 2018-035 as amended, thus denying Appeal 2016-954, thereby upholding the Planning Director's invalidation of Registration 2016-954.
Thank you. Okay, so I have a motion and I have a second already. And can we give, all in favor say aye? Aye. Opposed? 5-0. Okay, and he gets his time period to appeal. Now we're going to go on to item number 11. (2016-015). Sang Chan Sprayberry. Are you here for them? Okay. One, two. That one was continued. Okay. Okay,
Are you ready, Miguel?
Yes, I am. Good afternoon. This is Miguel with the Calaveras County Planning Department. Today, I'm here to present Appeal 2016-105 for Sprayberry. This application was denied for the same reason as all previous ones, taxes. So essentially, it was denied for violating local laws. The local law that was violated was 3.56.040, which requires that anyone engaged in cannabis activity pay the Measure C taxes. The appellant did not pay the Measure C taxes. As of today, they have not paid the Measure C taxes. In their appeal, they stated that the reason they have not paid the Measure C taxes is because they believe that the Measure C tax is illegal. That's all I have to present.
Okay. Would you like to come up and speak? And can you please state your name for the record?
Sanction Sprayberry.
Thank you.
Your Honor, I'm very sorry. Excuse for my language. Say, tax collecting is illegal. My English not too good, so I got invited from my friends. Say illegal is a little too strong word. It's not right. I apologize for that. So I understand I did not pay the tax on time, and I went to the tax collector. I did not know they have any plan. So I went. I know I don't have enough money to pay. So, but I still go see them anyway, and I go talk to the tax collector, and right after the extend the date lie out, and I do not know. So I go ask them, can I pay some parcel? I would like make a payment. They say, oh, it deadline is already passed, and I did not know have a payment plan. So I say, can I make a payment plan then anyway? She said, no, I have to come up with the full amount, which is 26,000 something, and I don't have that money. So that's the reason, I cannot make it.
Ms. Sprayberry, I want to make it clear, your appeal letter is saying that you don't think the tax is valid. We cannot decide that.
I understand. I'm sorry.
That's something that if you had applied for a redetermination with the tax collector, you could have started administrative proceedings where you're challenging the validity of the tax. We have to accept that the tax is valid and it's due and it's payable. And our only decision today is whether to affirm the planning director's action in denying your permit application because of the non-payment of the taxes.
I understand.
I just wanted to make sure you understand.
Right. Also, another thing, I also noticed that the mailing in here, it say it's supposed to be, my address is 6308, but right here, maybe I do not know, but 6333 Mountain Ranch Road.
Yeah, it's an incorrect address.
Yeah, it's not correct address here.
Miguel, can you check on that?
Yeah, it's a typo. It should be 6308.
I would like to come, but I just, you guys close 4 o'clock. I come 10 minutes right after 4 o'clock just to collect you guys, but it's not enough time for me. Sorry.
It's 6308?
6308 is the physical address. Yes.
Okay. Is that right on the resolution? Okay.
It needs to be corrected on the resolution as well, just for future.
Okay. So, does any commissioners have any questions? No. Okay. Mrs. Seng Chang, we're going to have you sit down so that we can see if there's any public comment.
Thank
Thank you. Is there any public comment on this appeal? No? And you don't have any rebuttal?
None.
Okay. Don't need to bring, okay. So is there any comments, any further comments from the commission? I'm going to close the public hearing and bring it back for deliberations here.
I think we're just stuck with a situation where, yet she couldn't afford to pay the tax, but the tax became due and payable, and there was no obligation of the county to publicize to any particular extent the payment plan procedures. It's admirable that they came up with any sort of payment plan procedure at all. And since we have no jurisdiction to rule on whether the tax itself is valid or not, I believe that the correct decision is to confirm the planning director's action in denying the permit.
Okay. Everybody else feel the same?
I couldn't add anything to that.
Okay. Okay, then I will pardon me? Well, I just didn't know if you wanted me to do that. Miguel, can you read the recommendation, please?
So staff recommends that the Planning Commission adopt Resolution 2018-030 denying the appeal for 2016-015 and thereby upholding the Planning Director's determination to deny application 2016-105 amended to show the correct address.
And
Correct spelling.
Miguel,
Sprayberry.
spelling.
I teach you. Sprayberry.
Okay.
Misspelled.
All right.
Also, you weren't here for the earlier, but we have inserted new stock language
All right.
in here about what has occurred in the past, and so if you're prepared for me to make a motion, I can do that.
And the
Yes.
city county needs to be fixed.
So, right, so just to summarize, the changes to the resolution are to correct the address 6308, to add the letter Y to the appellant's last name in the be it therefore resolved sentence, to capitalize county in the following sentence, and then to add the language that we have been adding to the indicated resolution, starting with the Lefevre appeal. Thank you.
That's the motion I'd make. I just did.
Okay, so we have a first and a second. First, need a motion? Got a motion?
That was a motion.
Where's my second?
Second.
Okay. All in favor, say aye. Aye. Opposed? No? Okay. Do you want to read her appeal rights, Peter?
This action is final unless it is appealed to the Board of Supervisors within 15 calendar days. You may appeal till the denial by the Planning Commission is final. You have the right to appeal this decision to the Board of Supervisors. It must be done within 15 days. At the Planning Department, yes.
Thank you. Okay. This is going to be the last hearing of the day. So we have applicant Leisure Resources, 2016564, and you're doing that, Miguel?
Yes, I am. All right, so once more, this is Miguel here to present Appeal 2016-564 for Leisure Resources. This appeal was denied for violation of 17.95.165.7, which states that as of May 10th, 2016, all grading and earth movement on the portion of the parcel to be used for cultivation shall have been completed, other than the grading necessary for a proportional adjustment to the cultivation area to comply with the setback requirements of this chapter. A registrant seeking to conduct grading for this purpose beyond May 10th, 2016 must provide the Planning Department with a copy of a current grading permit for this proportional adjustment at the time of submitting his or her application for registration. No additional grading or earth moving for the purposes of establishing or expanding any commercial cannabis cultivation site shall be permitted after May 10th, 2016. The biggest point to this is the opening statement or the opening sentence to this provision that states that as of May 10th, all grading and earth movement must be completed. A little history on this, or a little context to this. The subject parcel is located at 6721 Quartz Mine Road. It's a 15.5 acre parcel. It is highlighted in red on the overhead. This is what the cultivation area looked like on May 31st, 2016. As you can see, there has been some grading done or vegetation removal of sorts. There's stockpile of soil as well. However, at this point, the cultivation area still retains a natural slope to, at least to me, it looks like a natural slope. There might be some grading over here where terraces were made. Aerial imagery from June 9th, 2016, 10 days after the previous image, you could clearly see terraces that have been created for this. And then lastly, aerial imagery from June 28, 2017, the whole cultivation area has been completely redone. As you can see, all of this has been flattened out, and there's a big cut right here, and the terraces that were there on the previous year. This is a comparison of what it looked like from May 31st, 2016 to June 28th, 2017. You can see that the changes are dramatic. Please note that this tree has been removed. It's no longer on the parcel. There's this little tree that remains that was there on May 31st. These are images from a code compliances inspection that was conducted on March 23rd, 2017. As you can see, this is where the natural terrain used to be, in the back over here. You can kind of get a glimpse if you look past the hoop houses. This is the slope that's on the western portion of the cultivation area. As you can see, it's a significant slope. This right here is a terrace. This is that tree that remains. As you can see, this is what the natural topology of the cultivation area was. This is the elevation of it, and this is what it is now after the grading and the earth movement was done. Once more, here's a picture of that tree. This image was submitted by the appellant on Monday of this week, I believe, just to kind of show the commission that this area it's a very good cultivation site. It's clean, there's grass, there's fencing, they're in compliance with, for the most part, everything with the urgency ordinance, except for the grading beyond May 10th, which has no remedy. Now, a little bit of a background. So on June 23rd, 2017, code compliance went out there. They had an inspection. There was a few violations, including not having a permit for the grading that was conducted, as well as hoop houses that needed to be permitted, electrical and other such like things. The appellants...
Excuse me, wasn't that in March 2017?
March 23rd, 2017.
Yeah, okay. I thought you said June.
Oh, no, March 23rd, 2017. The appellant promptly corrected all the deficiencies in his cultivation area, submitted proof to code compliance, all the proof that code compliance needed in order to assert that they were in compliance with or that they corrected all the violations. However, prior to code compliance signing off on the site inspection as good to go, aerial imagery revealed that the grading that was conducted happened beyond the deadline of May 10th, which is, once more, can't remediate that. So the claim isn't that they expanded, the claim isn't that they created the cultivation area beyond May 10th, just simply that they conducted earth movement on the portion of the parcel to be used for cultivation beyond May 10th, 2016. I believe that's all I have for right now.
So the question I have is that code compliance in their email of Friday, March 24th listed a number of corrections that have been identified which need to be completed in order for the site to come into compliance with the urgency ordinance. And one of those was the grading. The grading that has been carried onto the property requires a permit which can be obtained from Public Works. From your presentation, I don't understand that there has been any further grading after March 24th, 2017.
I don't believe there has been any grading beyond
And
that.
that the applicant has been taking steady steps to get the permit for the grading that had been completed before that, thus expending time, energy, and money to bring the site into compliance with the urgency ordinance, if we go by the language of the
Email.
Code compliance could have said, you've graded since May 10th, and we're going to recommend denial.
Well,
I realize they're not speaking necessarily for the planning department, but if I had read this, I would have thought I could bring my site into compliance with the urgency ordinance if I do these things. And
Well,
I do.
I wanted to make a few points on that. The first point is that the aerial imagery you see to the right that shows the difference in grading, that didn't come out until 4 months after code compliance initial.
But code compliance pictures that you're showing us, you use them to establish the grading. I
I'm
mean,
not
there
ma-
you can see the hill that's resulted in here. You can see the trees still on the hill. You know, I mean,
Yeah,
it-
I totally
the
see. I
grading's
understand what you're
there.
saying, definitely. But I don't know if it's code compliance's procedure for one to look at aerial imagery either,
No,
be it or
I don't
or not.
think you need aerial imagery to establish. There's been a heck of a lot of grading since May 10th.
But what would tell code compliance that it happened beyond or before May 10th? That's the question. And then secondly, another point that I wanted to bring up is that regardless of cannabis cultivation or not, the amount of grading that took place on this parcel requires a grading permit no matter what.
No, I understand that.
And then lastly, code compliance in that email, if you see there's an attachment which says adequate evidence information sheets. If you look at that attachment, at the very bottom it says that making any of these fixes does not guarantee that your application will be approved as well, which county council has worded that language as a disclaimer, in a sense. Or if you want to talk.
Compliance had no idea when the grading occurred. They just knew that it occurred and then needed to have a grading permit. And it was only when Miguel grabbed the file and started reviewing it for compliance that he noticed that there would be grading after May 10th. And I mean, had the appellant, explained to code compliance, hey, I did this after May 10th, I'm sure that code compliance would have said, oh, and alerted the planning department of that fact.
Maybe we ought to talk with Mr. Code Compliance back there. Is that okay?
Yeah.
Sure.
Tom Watts with Co-Compliance. As Ethan and Miguel have already said, I wasn't aware of when the grading was conducted. Had I known beforehand, then I probably would have mentioned it. But clearly I didn't pick up on that fact.
So when you saw the grading that had occurred, you were making an assumption that it had happened before May 10th, 2015?
Yes, I think so. I think based on the fence and the hoop houses, I assumed it had been there a little while, but clearly not in this case.
And so what you were saying is if, in your mind, with that assumption, they still didn't have a grading permit for the work, so they needed to have the permit
Right.
in order to bring
A
it
grading
all up.
permit is required regardless of when the grading was done. But I didn't see the aerials and didn't check the file to see whether they had included that in their application.
And do you see any contradiction between, on one page, assuring them that these things need to be completed in order for the site to come into compliance, and another page saying this doesn't guarantee that you'll be in compliance?
It's, yeah, I know this has been brought up in previous hearings that the wording in that email is somewhat misleading. Obviously that's been corrected since then, but unfortunately can't go back and change
Can't
the
go
emails
back
I've
then.
sent.
Thank you.
Okay. I'll bring the appellant up. Okay, thank you. Hello.
Good afternoon.
Good afternoon.
My name is Sarah McCarthy, and I represent Leisure Resources, Inc., the CEO, and Owen Guyan, the landowner and property owner, as well with me for the property that we have in question for the grading that we've been denied for our application.
And so I'd like to take over because I've primarily worked on all of these applications because
Okay,
I'm the...
so I'm going to have you state your name for the record and sign the sign-in sheet, please, if you don't mind. We'd appreciate it.
Owen Guyan.
Thank you.
Good afternoon, County Commissioners. My name is Owen Guyan. I'm the landowner of the property located at 6721 Quartz Mine Road, which is appealing the denial. I have pulled all the permits for Leisure Resources. We have lived in Calaveras for 5 years now, and we're here before the so-called green rush. We have invested a lot of money into our site and property and have always been proactive with the planning and building departments. We have an established history with planning and building departments, and we have an established history of getting permits for the property over the last 3 years. Building permits, electrical permits, and a grading permit, which we have gotten the grading permit and it was finalized by Calaveras County Public Works. We have spent a considerable amount of money building what we consider a small compliant cannabis cultivation farm. In January of 2016, I went into the planning and building department to get permits to erect 4 greenhouses and modify our site that you see in front of you. I brought in a very detailed, up-to-scale site map showing the greenhouses, the layout, the power, and the water. I went over the site plan in great detail with the planning department, and unfortunately that employee is no longer employed with the county, but the planning department approved our request for our permits to build the greenhouses and the layout, which we show on that site plan. We were told we could move forward with the greenhouse permits and the build-out. We have all these greenhouses permitted, as well as the site plan signed off by planning and building. We did everything we were supposed to at the time, asking what to do and what needed to be done, and giving the right to go ahead. We came down to the county building, sought authorization, were given authorization, and proceeded forward. We had our cannabis inspection May of 2016 with Thomas. I felt that it went very well. We talked with code inspectors, showed them every part of our cultivation project, all of our current permits, past permits, and explained our cultivation plan. Site inspectors were pleased in the care and the condition of our cultivation site, our plan moving forward, and the care of the property in general. We were also given a list by email following that visit, and were asked that these items be corrected, which are the items that Mr. Laddish brought up. We started fixing those requested items immediately and have detailed with Thomas at Code Enforcement showing the corrections were made. The cost of those corrections probably totaled in excess of $40,000. After months of engineering and waiting patiently, we finally got notification from Calaveras Public Works that our grading permit was ready for final inspection of March 2018. Josh from Public Work came out for our final inspection. He asked that a couple culverts be installed and just some more straw work onto the hillside. We made those corrections right away and had him back out the following week. He approved those corrections and finalized our approval for the grading that was done on the property. We received our letter of denial 14 days after receiving our final grading inspection. All of the work would have never commenced if we weren't given the go-ahead from the planning and the building department to begin with. The department signed off on the work being requested, and this documentation should be in our file, and I have that site plan handy if the commissioners would like to see that they signed off on it. I feel as though they should have never given us the approval to proceed with our building plan and do the extensive work we requested. It was only on the basis of this approval that we undertook these activities. On top of that, the grading we are being denied for, we have a final permit for, and followed it through to the very end till it was finished. We have a final permit for it, and it allowed it, We have a final permit for it and allowed it until it was finished. We never increased our garden size or ever added to it. In fact, we decreased our garden size to 5,500 square feet at the beginning of this year in 2018, which Miguel and Mr. Moore can confirm. I have worked with Miguel on all my projects that I have undertaken on the property and have always been very truthful on our projects. I respect him and the county board very much. I've always appreciated his time and helpfulness. He can speak of my character and how clean and nice our property is. I ask that you look at the most recent picture of our property. Once the grading was approved, we have done extensive native grass work and proper care to have seeded all the neighboring slopes as well as the top of the pad. We are current on all Calaveras taxes and have been in compliant with the request from the county from the very beginning. We currently hold a California temp state license, which the planning department approved for us earlier this year. Not only is our application being denied at the last minute, but this also halts all of our legal California cannabis commerce. We cultivate for Mercy Wellness in Cotati, California. They are a medically state licensed dispensary, which we strictly cultivate for. Having our application denied at the last minute doesn't allow us to continue supplying medical cannabis through the state's licensing program, which the county has allowed us to cultivate for the last 2 years. This is a simple case of misunderstanding. We have always asked for permission and paid the appropriate fees for work that we wanted to perform. Thank you for your time and resolution in this matter.
Thank you.
When was the grading, let's just get specific, when did that little tree get put up on a pedestal because of the grading?
After I got approval on the site plan from the county, from
But the site
planning
plan
department.
didn't indicate whether there was going to be grading or not?
No, but what happens when you go to the planning department and you're trying to get issuance, you have to look at the computer and you kind of show them what you're doing and where this is relation to your aerial views of the property.
So they were agreeing to placement of hoop houses and et cetera, but they weren't then agreeing that you could do grading in order to accomplish
Yeah,
that site plan,
and I didn't ask either. I just presented what we wanted to do and what it would require. Yeah, I had never, up until that moment, had never dealt with public works or getting a grading application. What I kind of hoped is now, in hindsight, dealing with other departments, they'll put a stamp on something that says, you know, this is an approval, or make sure you don't do any grading. I think things have changed since then, and now they're very upfront saying, if you're making any improvements, make sure that there's absolutely no grading done to this site or it's being modified.
And yet at the time, were you involved in the application process for this property?
Yes.
And you were aware of the ordinance as it existed at that time and its provision that there couldn't be any grading after May 10th?
Yeah, that was my fault for being unaware of the actual wording in the grading as far as the application. I thought if I put together the site plan and went to the correct department and explained what we were doing, they would, you know, warn us or stop us or say, hey, whatever you're doing, don't move forward if you plan on doing grading. Because even during our site, this is the first time it came up when we just received this letter. Up until this point over the last 2 years, it had never...
Which letter are you referring to?
Our denial.
The denial.
Letter, yeah.
So well, I mean, it came up in the email from code compliance.
Right. Thomas asked us to have it corrected, and so right away we started working on having it corrected and getting the proper permit for that from Public Works.
During that time period, with the state of California application and the verification through the county of Calaveras as a planning department that they had required to pass us, to legally cultivate, we were fine and we got the green light, and then literally like a month or so ago, we received the denial, and so we were just taken a little bit back from that.
Did the subject of the grading come up when Thomas was there for this inspection in March of, what is it, 2016?
Yes,
Or
he took
2017?
pictures of the site.
Yeah, and did you discuss when the grading was done with him?
No, I don't think that the discussion of the grading came up at all. I mean, obviously it was brand new.
It had been graded.
I mean, it had been graded right then, like 2 months before, according to the site plan. So at that point during our inspection, we were just showing him what we were doing, what we had done, what we were building. Then he handed me that list in person, the same list that he had emailed, and we just immediately started working on the corrections to show the county that we wanted to be in accordance with everything that they're asking for.
Through the transparency with Thomas and our communications, we had assumed with him being on site and with the requests that he had been providing us in an email that we were moving forward to be able to do what he was asking and be compliant, because that's all we've been trying to do.
And could you elaborate a bit on how it was? I mean, I know we've just seen the pictures.
Yeah.
Why would anybody think that maybe that had been done before May 10th, 2015? Or I should say, why would anybody recognize that it was new grading that had been done after May 10th, 2015?
Well, one is, obviously, speaking of the Google Earth showed our prior cultivation site.
Well, yeah, but this was before planning department had done any of these aerials, as I understand it.
I would say if you look at the site, the straw's brand new, it's really fresh. The cutting was done just 2 months prior to this. So it was, when you cut land like this, it's really obvious that it was just done. It had no time for like the grass to, we hadn't been able to do all the seed work and the restoration with erosion control, grasses. It's taken about
I think our little tree also would have given it away.
I might even have a name for that tree, I should think.
It's our meditation tree.
I may have not heard you correctly, but was there a site inspection in May of 2016?
It was May of 2017.
March of 2017?
Yeah, there was no inspection for 2016.
It was March of 2017, wasn't it?
Correct, a year ago.
You said May of 16 the first time. You said May and you said 16.
I apologize for that.
Both.
Our inspection was 2017.
Yeah, and when did you present the site plan? Maybe that's the confusion.
January 5th, 2017.
17, okay.
17, okay,
Correct.
you had said 16.
I'm sorry, 2017. So before we did any of the cutting or the building or anything, we provided this site plan to the planning and building department, because you're required to speak to these different departments before you commence in any work.
All right,
What did you do
so
back in 16, May and June?
I'm sorry, we cultivated in 2016 just on the land. I then went to the county January 5th, 2017 to update, build the greenhouse, and change the style of the grow because we wanted to go into greenhouses. And that's when I presented that. We then had our inspection 2 months after that with Thomas in code enforcement.
when was the grading done?
January, 2 months before the inspection of 2017.
All right, now,
So simple timeline, sorry to make this confusing. January of 2017, I went into planning and building department with our site plan and our plan of what we wanted to do. I had approval on that. I started that right away that month in January. We then had our inspection 2 months later, which would be March of 2017.
okay, so prior to January of 2017, had you done any grading on this parcel?
No.
For cultivation?
Just wheelbarrow and hard elbow grease, hard labor. Like if you see the earliest pictures I just used a string line and tried leveling out my pots, but there's no mechanical grading done on the site.
Okay, and then commencing then in January of 2017 is the first time you started grading to put in the hoop houses and all of that?
Correct.
And you have any indication of how many cubic yards of earth got moved?
I can look on the grading permit for you and see if they tell.
Be interesting to know.
I can also hand this to a commissioner if you understand these maps a little bit better than I do.
No, I'm sure that's not the case,
Okay, it says the
at least as
estimate,
far as this commissioner is concerned.
estimated quantity of cut material is 1,750 cubic yards.
Okay, thank you. Okay, were you not aware before January of 2017 of the provisions of the urgency ordinance that says all of the grading for purposes of cultivation had to be done by then?
If I would have never moved forward with this if that was the case.
Well, we're kind of stuck with a situation where there's obviously grading.
Right.
It's just flatly prohibited by the ordinance.
And in hindsight, I'd hope that, by not knowing all the laws and the rules, by going to those departments and saying, this is what I want to do, I'd have a little more leadership in, these massive decisions that I'm making that could, deny us a year later.
Okay, when you came in January of 2017, was there any discussion or any presentation in writing by you that you were planning on doing some grading for cultivation purposes?
From just the site plan.
Well, does the site plan show grading, or does it show the location of the hoop houses?
It just shows that very particular cut box and where the greenhouses would go.
Does the site plan depict what you see if you're just looking down vertically at the ground?
Correct.
So it doesn't show any changes in elevations, correct?
No, it doesn't.
So was there anything that you presented to the county in January of 2017 that would have alerted them that you were planning on doing substantial amounts of grading?
No, it wasn't, besides just our conversation looking at the aerial view of the property.
Well, I thought I heard a suggestion by you that the county should have told you that the urgency ordinance prohibited grading, and I'm trying to find out how the county was supposed to know that you planned any such thing.
It just, with my dealings with Public Works in certain things in different departments, they say, you can't do this. Are you planning on doing any of this? Or they'll stamp it. All I'm saying is that when I went there, they didn't say anything that you're not allowed to do any grading. They didn't stamp our site plan. And I'm not trying to put this blame on the county. I'm saying there's this miscommunication by me going there and trying to seek approval. But this was missed. And then, almost a year and a half later, it was a surprise, thinking that we're doing everything that we're supposed to do to bring it up to accordance, that it was now an issue and it wasn't brought up back then.
I think
You may understand that the county may have thought, or the county officials may have thought, that you already knew about the provisions of the urgency ordinance and didn't see any need to tell you about them.
Did Thomas approve that? I think that in dealing with Courtney, Thomas, Madeline, Miguel, all of the people, we were trying to be as transparent as possible when we were trying to make this change, and that bringing all of forth the information and trying to be as compliant as possible, it was obviously something that was kind of slid through the cracks, it seemed to be, and that even after a year or whenever half a year had gone by and that we had gotten our approval with everything, that we were denied, and so we didn't really understand how it had gotten that far, and we had spent that much time and money trying to invest in the changes that the compliant department had told us to do, and so I think that that's where we're at.
Once the grading permit became an issue, and you had your engineers out and everything else, was anything needed to be changed to the grading that had been done? In other words, did somebody say, oh, wait a minute, no, in order to get a permit, you're going to have to move this dirt there, this other dirt?
Yeah. I had the inspection with Josh, and it was quite the opposite. He commended on the work that was done and how clean the site was and how well we had done as far as erosion control and to bring that site, up to natural vegetation and what's around it.
Is that one of the comments that we have in the file? I mean, you have several comments about people saying this is a good operation. Was that one of those?
Our first inspection, when he came out, he gave us, which should be in our file, it was just a copy called an inspection report, a pre-con, and he just wrote a little paragraph that I could read to you.
Okay.
And so this is from Josh at Public Works, who was inspecting the grading that was done. I arrived at the site at 1:30 p.m. and met with Owen Guyan. I spoke with Owen about the installation of his BPMs and that needed to be put in place to finalize his grading permit. On the pad, I told him that any bare soil had to be covered with straw and seeded. On the slopes, there were 2 eroded areas that had to be fixed. Owen told me that he would be putting in an overside drain. I told him if he does that, to put in an energy dissipator and to straw and seed the distributed areas. There was one other area I talked to Owen about as far as erosion control as well. I told him that he needed to wattle and install straw and seed as well. For a final of the project, we will need all item above addressed in the letter from the engineer along with the compaction reports.
So no changes? No, he didn't say you graded this at too great a slope or...
Right, all that was fine. He just asked for 2 culverts to be put in where you could just see water was heavily traveling. And we fixed that the following week.
If you needed a, we have, if you would like to see. Oh.
Do you have more questions? Okay. And let us go to take some public comment if there is any, and then...
Thank you.
Thank you.
Hi there.
Hi there.
I just wanted to come today and speak on behalf of the applicant. I'm one of the neighbors in the Hanson Ranch subdivision, and I've been in Hanson Ranch since 2010, born and raised in Calaveras County, and have seen the surge of cannabis growing, and saw where it began and saw where it is now. And all I can say about Leisure Resources is that not only are they great neighbors, but their farm is one of the most outstanding farms in this entire county. Everything about it, its cleanliness, its organization, the high level of construction, every last piece of that farm that you see is to perfection. And I think it holds the potential for an exemplary farm for the Calaveras County community in the event that we can actually go forward and support cannabis cultivation. This farm has the potential to be one of those model farms that holds a status quo for what we want to see in this county, instead of all the other half-assed done things that are popping up all over the place, which serve as eyesores to all of us that have to look at that every day. So for me, being in that neighborhood, which is a great neighborhood, it's a homeowners association, these guys participate in all the work activities. Like I said, they're great neighbors. They're very open about their farm. They've welcomed us all to come up and see their farm. And in seeing their farm, all you can say is, wow, this place is spectacular. Beyond the grading, I know that's just a logistical thing, but however, just the support and encouragement on how truly this farm has the potential to act as that example of what we want to see in Calaveras. It would be a shame to see it denied.
And what is your name, please?
My name is Jens Jarvie.
Okay.
Would you mind signing in?
Sure.
Thank you.
Where's the pen?
There's no pen.
No pen?
There
Cat-
was a pin.
Kaz stole it.
Thank you.
Thank you. Got your pen back?
Yep.
All right.
And I'll sign in too. Okay, Trevor Whitkey, CCA, here to speak on behalf of the registrant. I know him as Lance, but this application and this hearing is very similar to some previous hearings. It's already been alluded to. I believe that Lance did everything he wanted to do it right. Not all of us are lawyers. A lot of us are learning in a crash course way what all of these legal ramifications are and how to read a ordinance line by line and take every word to its literal specific meaning. So the issue is that if you actually read 17.95.165.3n.7, the final sentence says, no additional grading or earth moving for the purposes of establishing or expanding any commercial cannabis cultivation site shall be permitted after May 10th, 2016. Now, I fully understand and I get that the first sentence says all grading in the area for purposes of cultivation has to be done prior to May 10th. However, the applicant had established a cultivation site. The applicant also submitted a letter requesting a reduction in his canopy site. He stayed within the frame, the size of the area that he was already cultivating in and went smaller. He submitted a site plan on January 5th, 2017 and said, hey, I want to put a greenhouse here, 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 and here. Now, the only way you can put greenhouses in all of those places and actually have them work is if it's level. So implicit in that request is the ability to flatten that space. He was granted the authorization to move forward with 4 permits on January 5th, 2017. On March, he has his inspection. The inspectors see what has happened and tell him, here's a checklist, do all of these things. He does all of those things, and literally within days, weeks of him completing all of the requirements, spending, he said $40,000. I look at the list and I see 6 figures. That's a lot of things that he had to do. He pulled a lot of permits, and his administrative record should be about this thick with all of the permits and site plans that he submitted. He's done more in terms of building and permitted building, authorized building, than pretty much any applicant I've seen in this entire county. And I've seen a lot. And so he was given authorization to continue to move forward with this activity on January 5th, 2017. He engaged in the activity. He was then told to incur incredible expense to further come into compliance, and that in doing so, he would be authorized to engage in the activity. We all know a certain somebody was put in the same situation, and we know that the grading that she did was egregious. And we know that this site relative to that site is a world of difference. And I know we don't want to go on precedent, but I do think that clear direction was given to the applicant. The applicant was told to engage in particular activities. They did, and they came into compliance, and is now being denied for having engaged in the activities. They could have said on January 5th, no, stop. Do not build greenhouses. Do not flatten this area. You are not allowed to do that. There was a 1795.165.397 says clearly you can't do it. And had he been told that, he wouldn't have done that. It also says no additional grading or earth moving for purposes of establishing. He had already established, or expanding. He wasn't expanding, he was reducing. can see that there's room for misinterpretation, and there wasn't clear guidance provided for the county. In the absence of clear guidance provided by the county and a good faith effort by the registrant, I see no reason for the denial of this application. It's very similar to past cases, and I think this applicant is more deserving, pure and simple. And I think a lot of you probably agree, having gone through the specifics of the case that I'm not referring to by name.
Got it.
But finally, all of my survivability arguments also apply here.
Are noted.
Yes. So I don't think there's any authorization. 1795165.397 isn't on the books. It's not there. You look on the county code right now, and you will not see that there. So the denial after February 14th for grading after May 10th, sorry, if it applies to him, it applies to the county too.
Okay. If there's no further public comment, I'll close public comment. And do you have anything further you want to add?
When Miguel first started thinking about denying this one, he called me over to look at it because he looked at it, thought it was a really beautiful site, that it was way better than most of the ones we've seen, and then was impressed that it had gotten all the permits. But we looked at it, and we have denied many people on the basis of grading after May 10th for the purposes of establishing a cultivation site. And it's true there was a cultivation site already there, but the grading was for the purpose of this particular new formulation of the grading of the site. And so with reservation, we both decided that we got to deny it. And for those reasons, we feel the commission should agree.
Is the language that's in the March 24th, 2017 email the same language that we encountered before when we did?
It's the exact same language that was in the email that went to Sarah Hodson, but Sarah Hodson didn't have the additional notice that went with it that has the disclaimer stating that correcting the violations listed above is not guaranteed that your application will be approved. Failure to provide satisfactory proof of correction within the time frame given by the issuing code officer may result in the issuance of an administrative citation or recommendation for denial. So the purpose of that additional sheet is to say, look, these things have to be fixed.
But you're saying that the purpose of it is we don't really mean what we say the page before, which is, we're talking about reliance and good faith reliance on what the county has presented, and we have in this case a very, as you say, a very clean, well done site, whereas before on the Sarah Hodson we had, I think the term was egregious, grading misdeeds, and we permitted her to solve her problems. Here, the only problem really to be solved was the grading was good, fine, but you needed a permit. And if we're going to do it on the basis of the boilerplate language that's on a second page, when the thing that's addressed to the applicant says, you do this, in effect, do this, you will come into compliance, I'd say that that's a very specific language over general language in a boilerplate situation.
Yeah, I mean, so it sounds to me like you're worried about a detrimental reliance in a estoppel type of situation, and government estoppel has very specific elements that have to be satisfied to have government estoppel occur, and one of them has to be a deliberate efforts to deceive, and then another one has to be it would subvert a strong public policy. And
I'm also looking at our previous action.
Sure, and I'm not a huge fan of bonds.
I understand.
And nor do I think those elements were satisfied in that case either. But
this, when I looked at the pictures in this case, I thought, how refreshing.
Yeah.
How refreshing. We're not talking about human excrement. We're not talking about stealing water from neighbors, and then we have letters from the neighbors saying how great they are. And we still have the same language saying, well, you do this, you'll come into compliance.
Yeah.
And I tend to agree with the applicant, and I'm saying this so that you can have a chance to rebut, that this grading was not 2 years old when the pictures were taken in March 2017. I mean, it's fresh stuff, especially after such a rainy season that we had had in 2017. You know, I think it would be reasonable for the applicant to assume that the code compliance person recognized that this wasn't 2-year-old grading or more than 2-year-old grading that he was looking at.
Yeah, I mean, in response to that, I would just simply say that it, despite the language that Tom had in his emails, there was just boilerplate language that he used in every single email in order to come into compliance with the urgency ordinance, which is a very regrettable language, admittedly. His role is simply to identify code violations.
I understand.
And not to do any investigation beyond that. And there is that regrettable language in his email, but he carried out his role, which was to identify the fact that grading had occurred. He probably looked at it and thought, hey, yeah, you know, there's grading here, and then he could tell that it had been unpermitted, and so he simply just said, look, you need to get this permitted. And
which they did.
Which they did. And but it's really not Tom's decision as to whether or not it comes into compliance with the urgency ordinance.
I understand that, but he's the representative of the county there. The person takes action on what he says that costs them tens of thousands, if not $100,000.
But
He still had to come in compliance.
yeah, he
with
had to
the
get the grading permit, whether he's going to not have a cultivation site there at all or not. I mean, the grading permit has to occur, and Tom doesn't have the authority to waive requirements of the code or to absolve a person of liability for violation of the code. Mm-hmm. I mean, he just can't do that.
From the point of view of the applicant, it appeared as if he could. Is that what you're saying?
That's what you're
No,
saying.
That's what you're saying.
Yeah.
Is that what I'm putting in your mind?
No.
Is there any other comments? I kind of would like to ask, we'll come back to you next. I wanted to ask Thomas a question, if he could come up, please.
Sure.
When you were out there and you seen the grading, did it look real fresh to you?
It didn't occur to me at the time that it was that fresh. Typically, we see tire tracks. It's, as everyone said, it's a clean, tidy site. There wasn't the usual,
Right.
piles of dirt and everything else that's usually left around after people have graded.
Did you ask them if they got a grading permit? Because you made a recommendation that they needed to get one.
I honestly can't recall any discussions of the grading. Clearly, I knew that they didn't have a grading permit. But beyond that, I can't remember discussing it.
Okay. That was my question. Does anybody else have any? Nope? Okay. Thank you. I thought, maybe I missed something here, that he said he got a permit before he graded and the county authorized it. Did I not hear that?
No, I heard something similar to that, but I think he was talking about the site plan.
That's right. Difference between the two. Never mind, I got it.
We have the site plan if you'd like to look at it. I mean, it's just a series of geometric shapes.
I believe I emailed this to you last week.
Yeah,
That's what that is.
so when Madeline looked at that, all she would have been looking for is whether or not there was going to be setback violations. And she would, I mean, it doesn't have any topography on it. She would have had no idea.
But those things weren't there when they submitted the site map?
No, the greenhouses, no, they weren't there. They did get permits. I think, if I got everything correct, they got permits before they built the greenhouses. But they didn't get permits for the grading.
guess I confused site permit with grading permit.
And the site plan itself takes in, well, at least a considerable area. And I guess the position of the planning department would be that, I guess this is a flat place, is that right?
Well, this is the aerial that we're looking at, so when, right here, so when somebody comes in with a site plan and says, we want to build 4 hoop houses on this, we look at the what's it called, the aerial imagery and say, hey, yes, you are 75 feet from the property line. At this point, we're not looking at topography, we're not looking at elevation, we're not looking at grading.
I thought you didn't look at aerial imagery until after.
No, for a site plan for the hoop houses, when somebody comes in with a building permit,
Yeah.
we look at our aerials to make sure that they're in the correct zoning and that they meet the correct setback requirements. That's what we're
And
looking
so
at.
from that aerial, you could have told whether or not grading was required?
No, I think what we're saying is when they came in for review of the site plan for a building permit for the hoop houses, this was the aerial image, the most recent aerial image that was available at that time. And I would agree with Miguel that we look at it and we say, okay, they're proposing hoop houses on this existing topography. They didn't show us they were going to be grading. There was no indication that was going to occur. It wasn't until after the grading occurred that the next set of aerial imaging, which was taken in the summer of 2017, showed a significant amount of grading.
But when you showed us this picture before, I thought you indicated now there is some grading shown.
Yeah, definitely, and that's after it's been denied and I'm formulating this staff report, I'm actually having a really, really close look at the pictures of what has happened. I'm comparing this Google Earth imagery, which our front counter computer doesn't even have, to our county aerials.
But in that aerial, it looks as if there are terraces between those rows.
And we have seen hoop houses that fit on those terraces from other cultivators as well.
In this configuration?
Oh, well, first off, I didn't really take in the permit. I'm just talking to about how we take it. And I just wanted to add one thing. Mr. Whitkey said that this cultivation site's exemplary. You know, I fully agree that this cultivation site is exemplary. I've seen hundreds of these sites, and I've seen worse. As you mentioned, this site does not have toilet paper all over the place. There's no dead deers. There's no poaching, nothing like that. And I think that it's unfortunate, and it's just a series of miscommunications. You know, had the registrant at the time of submitting his hoop house or building application said, hey, I'm going to move in excess of 1,400 cubic yards of soil, we would have said, no, you're not.
That would have rung a bell.
You know, exactly. And then another point I wanted to bring up as well is when Thomas goes out there and you're asking him, does the grading look fresh? You know, there's a lot of things that go into that as well. You know, us in the planning department have denied applications for grading, and it turns out it wasn't grading at all. It was removing of vegetation,
Right.
you know, which would look like this.
I mean, when you
In-
get to
in
the
my
picture with a
opinion.
tree that's elevated by 15 feet, I wouldn't go for that.
So,
Nice try.
okay, is that your rebuttal? Are you good?
Yes.
Okay. You wanted to come up and rebuttal?
Yeah, I mean, I just really want the commission to know that obviously I really respect the commission. I really respect the planning department. You know, every permit that we've done on this property, electrical, building, I mean, a lot of permits, I've always gone and done them myself. And I've done that to save the thousands and thousands of dollars that it costs. And in that, I really lean upon the employees of the county in these different departments to educate me on what we can do, what we can't do. You know, there's a lot of laws and there's a lot of stuff that doesn't make sense. When I don't know what we're doing or what we can or can't do, I go to the desk and I say, can we proceed? This is what we'd like to do. I have extensive conversations with Miguel, extensive conversations with Thomas, even Sarah, like maybe a lot more than the usual people. Like we were trying to show evidence that we were doing this stuff, asking lots of questions. There's really there's no transparency between us. Like I've always come forward and really relied on finding the information that I don't know from the county employees that work in these departments.
You held up a site map and you opened it big and wide and you talked about how much soil was moved when he asked in the grading process, and you said 11, what did you say?
1,750.
Where was that submitted to? Where was that map submitted to?
That, I believe, Public Works.
And that was after you were cited?
Correct.
Okay.
The plan that I have, that I signed off, or that I had planning sign off, just shows basically what Miguel had brought up, the square of where the greenhouses are going, where they're being placed on the
Okay, but
property.
it didn't talk about earth moving?
No.
Okay. Okay.
But another thing I'd like to bring up is, with these maps, when you go into that department, they have the option of looking at the, and correct me if I'm wrong, Peter, but they can look at the slopes and the contour of what you're doing. There's these layers available in the map. So I remember looking at these layers and going over what I was doing, you know, like I just feel like if this was going to be such an issue a year and a half later, like we should have been stopped right then and say, look, you shouldn't be doing any grading. You shouldn't proceed and do anything to your site. The county's kind of, you know, we don't know what we're doing moving forward right now. You shouldn't do anything.
I just feel like we wanted to be as honest and upholding citizens of the county as possible, which is why it's funny, I mean, it's not funny, but all these people prior to us with taxes and everything, it's just crazy to me, like my public opinion of, you know, the things that you have to deal with. And we appreciate your time and the opposing side, and we just want to do things the right way and be that citizen in Calaveras County that is the example and that can lead for it, because, you know, the riffraff, I mean, everyone has an opinion about it, but we don't want that either, even though we're cultivators. You know, it's like we want something that is good for the county and that showcases and brings money also in jobs. So that's my final thoughts.
And again, the biggest thing is we would have not proceeded forward. Like, we didn't just do the grading and erect this and wait for Thomas to show up and then, you know, come before you and say, sorry, we just did it. You know, like, before this was ever done, we had this plan and we put together this site plan and we drew these drawings and they were to scale, and we came down before anything was done, you know, just because that's the law of the county. You know, if you want to do any work, you must come to these departments before you do it. And I feel like what we're being denied on was a miscommunication. Like, I understand my responsibility in it, and I would hope that planning would accept their responsibility in that as well.
But if you didn't get a grading permit before you graded, I mean, that's the problem here. Well, that and the fact of when it happened. So, you know, I think you've made your position very clear. And I think you're to be commended on the quality of your proper land stewardship.
Thank you.
Okay, so on that note, we'll go ahead and close the hearing, bring it back to the commissioners for deliberation.
Thank you.
Well,
Thank you.
I'd like to start if I could.
Go for it.
Okay. No matter how beautiful this property is, I would feel what brings me to the position where I think that this permit should be, or this appeal should be granted, is the language, which is the language we confronted before, that a certain number of corrections have been identified which need to be completed in order for the site to come into compliance with the urgency ordinance. And then the listing, including the grading. And they have now complied with all of these, if I'm correct, including the grading. They actually have the grading permit. That language, coupled with their actions and coupled with the fact that Thomas was not confronted with a terribly graded site, as we had in an earlier case, but was confronted with a perfectly well-done site that needed just some final tuning as to erosion and that sort of thing. I think with this language, I think it's, and what they have gone through and what they have satisfied in complying completely with everything that was set forth in that email, I think that we should grant the appeal.
Okay. Commissioner Wooster, you want to go next?
Yes, I'll go next. I mean, all of the evidence points to a exceptionally clean, well-organized, well-run, almost a model cannabis operation. But we do have this problem, and it is this grading in what I judge to be clear violation of the urgency ordinance. The first sentence of this provision makes it very clear that there will be no further grading except to accomplish the proportional reduction. It's quite clear. And the intent was to freeze further grading with that one limited exception which doesn't apply here. When they come in with the site plan, it didn't alert the county that they were planning on grading to put these hoop houses there. And I don't think that even if you assume there was some slope there, I don't think it's necessarily true that you have to grade the land, flatten it to put in hoop houses. People do put hoop houses in on slopes. And so I don't think that there was anything to alert the county when it received the site plan in January of 2017 that there was going to be grading as part of this project. And so I don't think the county was at fault for not bringing it up, and certainly the applicant didn't bring it up. With respect to the language in the code compliance inspection report, particularly this is what you need to do to come into compliance with the urgency ordinance. You needed a grading permit to come into compliance with the urgency ordinance no matter when you graded. You could have graded before May 10th and you'd still need a grading permit. And assuming one was required under the code, and it is, because otherwise you'd be in violation of other local laws, quite apart from the urgency ordinance. And there was nothing to tell Mr. Watts that this massive amount of grading had been done that recently. They could have just taken out the grass. And even if there was, the language that's been added to the code compliance notice takes care of what I might call the Sarah Hodson issue, but makes it very clear that even if you comply with this, you may not get your permit. So I think we're just faced with just a clear violation. A massive amount of grading shouldn't have been done, and it's not the county's fault.
I agree with Kelly, it's not the county's fault. It's obvious that grading was done. I mean, they're not even denying that, so. My issue is, this is the best farm I think we've seen so far. It looks the best, except for it's still out of compliance. The grading was still out of compliance. So I don't think that I can vote on it just because it's the best looking farm we've seen so far. And it is by far the best looking farm we've seen so far. But I'm gonna have to vote to uphold the planning commissioner's decision, or the planning director's.
I agree. I don't like my decision, but because you obviously have spent an enormous amount of money and produced the best I've seen as well. But the code is clear. If you were misled, perhaps you should have read the code a little closer. You know, it's hard to read, but you know the old bit about ignorance of the law and that sort of stuff. It's a violation, and I don't have a choice.
Okay. needed a grading permit. This is a sad one because we have seen much worse. I'm going to go ahead and let you read the recommendation, please.
Staff recommends that the Planning Commission adopt Resolution 2018-037, therefore denying 2016-564 appeal, and thereby upholding the Planning Director's determination to deny application 2016-564.
So moved.
All in favor, say aye.
Aye.
Aye. Opposed?
No.
The motion carries 4-1. You want to read him his appeal?
So this action is final unless appealed to the Board of Supervisors within 15 calendar days.
Yeah. Okay, so the, any informational items, none, study session, none, commissioner reports, are there any reports from the commissioners?
Well, yes. District 2.
Turn your mic.
Central Calaveras.
Do you want to turn your mic?
Oh, yes. So everybody can hear. District 2, more particularly Central Calaveras Fire and Rescue Protection District, invites you all to participate in the mud run that's coming up on Saturday. And if you don't want to actually run in the mud and slop around in the mud, well, you can come and watch crazy people like myself do that.
You're going to run in the mud?
Well, I'm going to at least start.
This is enticing.
Exactly what this means.
This is at the Mountain Ranch at the community park. That's where it starts. And there's a children's mud run also.
Downhill?
It's leveling up and down.
Well, we're very proud of your enthusiasm.
Yeah, I noticed respect wasn't in that statement, but
I totally respect what you're doing. Are you kidding? That's
anyhow,
awesome.
that's my report.
And I love that you support your fire department. Any other commissioner reports?
No.
Nope. Okay. Planning director?
Nothing unless you wanted me to respond to the question raised at public comment.
And could you give those figures where I think?
Off the top of my head, it was approximately 320 that had been denied, 210 that had been approved. There were 109, this was as of Tuesday, 109 that were still pending review, and the remaining ones have been withdrawn.
Okay. Thank you.
The question was, are we still processing applications? Yes, we are. We believe that the registrants who applied under the provisions of the urgency ordinance when they applied have a right to have a completed review of their applications. Even though the ordinance has expired, the provisions of that continue until they have a right to continue to cultivate under those provisions of the ordinance for 90 days after its effective date. And so that will be June 7th. Funding for review of that is under the fees paid for the review of those applications. That will stop also. We will not be drawing from that fund after June 7th.
So after June 7th?
But we will still be processing any appeal, but the cost of processing the appeals will be funded through the general fund.
So you will no longer be processing the applications after June 7th?
We intend to have all applications completed by June 7th.
Good for you.
Somebody asked me a question about a couple weeks ago, and I didn't know how to answer it. They're asking me, when you are picking them, how are you picking which application you're going to process next?
As we've been doing it more or less in chronological order, except that as we receive information from other departments, whether it's a denial of the background check, or a failure to pass the site inspection, or we receive information from another agency that they didn't get their water board notice of applicability, for example. Those failures will sort of like, okay, we'll grab those and deny them. And then it's just a continual process of the ones that are still outstanding. And then we have a lot of those, for example, the corrections of the alter ego issues. So taking a lot of time to work on, and so as we resolve those, then we say, oh, this one's finally ready to be approved. Good, we can sign off on it.
Did we really vote in favor of the Hobson case?
Yes.
That you did.
We had an email from code compliance that.
We did.
We did.
The majority of the commission did, yes.
Sorry. Oh, I had a question. Nobody's here, right? But we're on TV.
We are, the meeting is
Does
still.
does the new ordinance require them to till everything back, return it to the previous condition?
It requires that adequate erosion control is in place. It doesn't require like regrading it back to its original
For example,
contour.
these people, can you grow tomatoes in the hoop houses?
Yes.
I don't want to get too far afield on non-agendized items, please.
Okay.
Peter made his report, and I think, is that the last item on our agenda?
The only other thing I wanted to mention was we're still working on the internal review of the general plan admin draft EIR. So, but I'm still hoping to get that out. Won't be this month, next month now.
And I don't think we were speaking to things we were going to vote on, so we're okay. Okay, so on that note, I believe our meeting is adjourned.